Hello, everybody. Welcome to the Outcast Podcast. Had a day or two off. Had some personal stuff I had to take care of over the last couple of days, but I am back. Day 150 of the YSL RICO trial. I have been watching the trial and keeping up with it, but I haven't been able to broadcast. Please like and subscribe, even if you never come back to the channel. I'm trying to grow the channel and trying to get out there. I've got a lot of podcasts that are fixing to come up. I'm working on now. The Rise and Fall of Alex Jones, The Rise and Fall of Alex Murdaugh. We're going to go back and look at the Menendez brothers. We're going to go back and look at Casey Anthony, Susan Smith, just a lot of different podcasts that I'm going to be doing here in a little while, just to get things rocking and rolling. But this is the YSL trial, day 150, and I've noticed a lot of things going on in this trial, and I'm trying to figure out why we haven't had a mistrial yet. This should have been mistrialed a long time ago. There's no reason for this trial to continue to. This trial shouldn't even be going on right now. It should have already been mistrialed. The amount of times the state has done underhanded stuff, and I mean underhanded as in Dennis trying to get in what he tried to get in underhandedly because these qualifications were questioned, and I agree with the judge on that. I do believe wholeheartedly that um, the state knew what he was going to do. The state knew he was going to say what he said, and it was all to get back at the defense team for questioning the qualifications of this guy. But this is the Young Thug trial, and I, I just can't. It's hard to comprehend some of the stuff that's going on here. It really is. Uh, with what the state is trying to get away with here and all that. But we are waiting for court start. They're showing an 8:45 start time right now with uh, the Law and Crime feed is showing 8:45 start time. Hopefully everything starts on time today. Go ahead and like and subscribe to the channel for me. It's free to like it, free to subscribe. And like I said, I've got a lot of content that will be coming out here soon. I'm working on the scripts and all now and getting my sources together. They won't be a live podcast. It'll be pre-recorded and edited and put together and put on the channel and a uh, certain playlist. I haven't decided exactly how I'm going to do it yet, but we're going to get it done. But folks, I really need your support here. All I'm asking for is a like and a subscribe. Help me build up my channel here. Help me get the outreach I need to get things done. I promise you, you will not regret it as soon as I get everything together that I need to get together. And the one thing I need is subscribers. I don't have a single subscriber right now. So just like and subscribe to me. Like and subscribe if you don't mind. And we're just waiting on court to start. So I'm going to put on some music. And I will be back in just a few minutes and we'll get things rocking and rolling here on the Outcast Podcast on YouTube. A little bit of music going for you, and we'll be back. All right, we're a little 5 minutes away from start time. If they start on time today, this is the Outcast Podcast here on YouTube. Day 150 of the YSL Young Thug trial. This should have been over 100 days ago. The longest trial in Georgia history could have been over already. Had Judge Whitaker just done her job, mistrialed this thing, she took over, started it from scratch, went through all the evidentiary ruling, but she knew what she had to go through, and she took over. She should have started over from the beginning, and she did. And it behooves me as to why she couldn't get her stuff together and already ended this trial. Should have been over. But we're still going because we have a judge that sees how much time and effort has gone into this trial already and has decided that she's not going to do a mistrial. And I can't understand why. But some things are, I guess, not meant for me as just a layperson to understand what's going on here. But I can't for the life of me understand why a judge who's sitting here fussing about how long this trial is taking isn't taking the necessary steps to speed this thing up by saying, okay, hey, this witness, and this witness are all going to testify about the same thing. This witness is going to bring in ABC. This witness is going to bring in DEF, whatever, and consolidate them down to one witness and say, I will let this one witness bring all this in. We're going to eliminate these two witnesses. But the state's not. The judge isn't doing that. The judge is letting them just continuously go on with the case to the point where I don't understand it. Why? Why are we continuously going through this case? I'm making adjustments to my mic here, folks, and I apologize. It wasn't on the right setting, but I just don't understand why things are happening the way they're happening. But again, the judge can control this stuff. The judge is choosing to let the courtroom run her, and she's not running the courtroom. And I just really don't understand it. That's the Outcast Podcast coming to you live here on YouTube, bringing you the truth, the whole truth, and nothing but the truth. All right, here we go. In the courtroom now. So now we're just waiting to see when they're going to start it up. All right, here we go.
Okay, this is just about scheduling. Well, it had been the understanding, I think, of the sheriff's office that y'all weren't going to use that witness at all. So, I mean, I don't know.
Yes, Your Honor.
Yeah, we had an issue come up, Judge. We can address.
Okay. Do y'all want to approach?
And we start off going straight to approach. Some of the stuff that they're not doing in front of the cameras, I don't know why they're doing things the way they're doing it, but it is what it is. Okay, we got Miss D. Williams, Abate, Atkins, I can't remember her name. She's off the defense team as well. Miss Abasi, Mr. Abati, D. Williams, Mr. Atkins are already up there at the bench. So we're just starting out and we're already at a bench trial, a bench conference. So there you go. So we're just sitting here waiting on, once again, we can't even start on time. Outcast Podcast coming to you live on YouTube. Day 150 of the YSL trial. Starting out going to the bench already this morning. How's everybody doing on this lovely day? I don't know what day it is. Let me see. It is Wednesday. How's everybody doing on this great Wednesday? I'm hoping everything goes good today for the YSL trial. I'm hoping there's no big revelations today that throw things into mind. What I would really like to see happen today is I'd like to see Brian Steele or one of the other defense attorneys come up with a really solid argument for mistrial that is so good that the judge just cannot turn it down. You know, the judge has got to be like, oh, wait a minute, I don't have a choice here. I have to do this. We're never going to see it, but I'd love for that to happen. Would anybody else here love to see that the state be told, hey, all this underhanded stuff that you've been doing is caught up with you finally and it's all over. These guys can go home. But another reason why they're not mistrialing, and I feel this deep down, one reason the judge is not declaring a mistrial right now is it's going to affect every plea deal that has been put in place, because the trial will have been stopped and they will not have to testify because they will not be allowed to retry the case. At which point, what happens to all of these people who had plea deals that involve them testifying against these 6 defendants that are on trial right now? What would happen with them when all of this goes away? You know, if mistrial is declared, then they have nothing in their plea deals that account for that. So do their plea deals go away and now they go to jail because they pled to these charges, or do the plea deals get dissolved and everything has to start over? I don't know. You just have to wait and see what happens. But I think that's one reason she's not mistrialing it, is because it's going to affect so many plea deals. There's like 28 people on this indictment. Most of them have pled out. A majority of them are now pleading. Another plea, you've got to go in and testify against Jeffery Williams and Stilwell and all these other guys. You got to go in and testify against them. And that is why they're not mistrialing this thing right now, because it's going to affect so many plea deals. Sledge would have to be released. He would not have to do 5 years. Woody, I don't know what happened with Woody, but and she didn't go after. They didn't go after Woody the way they went after Sledge, and I don't understand that, because Woody was like cooperative to a point, not cooperative to a point. But Sledge came out and said, hey, I didn't agree to this. We tried to get it changed. Brought his inept lawyer up to say, hey, yeah, we contested this. This wasn't in the original draft. This was added. This was taken out and then snuck back in on us. We didn't realize it was there. We figured it was the correct thing. I don't know. The state's been very underhanded and very dirty with what they're doing with this case. And but it is what it is, folks. We have to just deal with what we're dealing with. Go with the flow. Hope for the best. Expect the worst. That's Adrian Love, y'all, in the background. Oh, you want to hear her again? That's what I hear when Adrian Love's up there asking anything. All right, everybody. I got to run the puppy outside real quick because he's decided it's time to go to the restroom. So I'm going to take this banner down. I'm going to leave that banner there up. I'm going to put this banner up, and I will be right back. This is the Outcast Podcast coming to you live on YouTube. Day 150 of the YSL RICO trial. The state of Georgia versus Jeffery Williams et al. Right here on the Outcast Podcast.
Does anybody have a proposed instruction to submit? Or comments about the one that the court drafted?
I do, Your Honor.
All right,
Good morning.
good morning.
Can I just pull it up for a second?
Sure.
Good morning, Your Honor.
Morning.
On paragraph, it's in the alternative wording for Mr. Kendrick. It states, hold on, I've lost my place.
And it, honestly, I'm looking at it now and it may not even be 100% applicable. That second sentence in the alternate wording, I had just noticed that in the other guilty plea limiting instructions, that was more the language. So I was throwing that in for y'all's consideration as to whether anybody would prefer wording of that type to the couple of paragraphs above that. But yeah, I mean, whether another person has been convicted of the same charges isn't necessarily applicable anyway.
So, and my concern is that the Honorable Court's not addressing, yes, I understand that something could be used against, I'm just using his name, but Mr. Kendrick, not against the others, but
Right.
then it says that you can use the other evidence, and there's no instruction that that's only if the jury finds beyond a reasonable doubt that one or more of the persons entered into a willfully and knowingly, and
Right, but we're talking about overt acts. I mean, they're going to have to, that's another step or portion of what they're going to have to decide. And obviously, they're going to get full instructions at the end of the trial. So I'm not going to get into, here's how you're going to consider all of these different parts of the RICO count, you know?
I do understand, but as a listener, I guess, for a juror, they don't even get to decide the acts unless they first find it. They could do it any order they want, I guess, but they first find that there was a willful and knowing joinder of the conspiracy.
Sure, that's a part of what they're going to have to find as to each defendant before they can convict anybody.
And I'd like that language in any instruction, because otherwise, let's assume that this trial ends, the state rests in December. That's approximately a month and a half, maybe 2 months from right now. Meanwhile, the jurors are being conditioned, in my words, from the Honorable Court's instruction that, hey, yeah, we can use evidence against everybody except certain evidence. So I'm going to realize that this is against everybody before there's been no instruction to my knowledge in this entire case that they have to first find that there's a conspiracy, that a person joined the conspiracy. So
They're not supposed to be deliberating until the end of this case, the close of all the evidence, all of the jury instructions. So there isn't a danger of that.
okay, well, that's my problem.
All right.
Because
Well, I'm not going to give them a full kind of mid-trial mini instruction on how to consider RICO. They're not
Okay.
supposed to be doing that yet.
okay, I'm not trying to say a full instruction, but just a line, maybe. I put it in.
I mean, I can say, I'll give you further instructions later
I would,
on how to consider all of this.
and whether a conspiracy even exists or a person joined a conspiracy. That's what I'd like, because I do find, and yes, I understand that they'll be instructed later, but I do find that it is, jurors should have some context of this instruction. This instruction standing alone seems like it's already, that there's a suggestion. I'm not saying the court's doing it on purpose, by the way, but there's a suggestion that other evidence can be used against everybody. Well, that may not be true.
I'm only saying it as to if the state presents evidence aside from the guilty plea as to overt acts 56 through 59, and then aside from Mr. Ryan's trial conviction as to overt acts 79 through 81, which, I mean, they're certainly doing that for the murder of Jamari Holmes. They're doing it right now. So I guess I don't believe that it is broader than what this is saying, which is specifically as to those enumerated overt acts.
Now, I would like something, if you, ladies and gentlemen, find, based upon my instructions that will come at the end of the case or at an appropriate time, that one or more of the people on trial knowingly and willfully joined a conspiracy, and then go into something about, then you may not use the guilty plea or verdict, whichever.
All right, well, I
Against anyone
appreciate
else.
that, but I don't think that's necessary,
Okay.
and I don't think that this misleads them into thinking anything at all
Okay.
wrong, really. Okay.
And
So,
I still believe my original that the evidence shouldn't come in at all, because I'm struggling with the instruction. So,
All right, well, I
with that
think
being said.
in terms of if anybody would prefer the language, you may not use this conviction in your consideration or deliberations against any of the other defendants in this case. It is not evidence of anything against these other 5 defendants. Each defendant has a right to have his guilt or innocence determined by the evidence presented against him, not by what happened with regard to a criminal prosecution against someone else. That's one version. The alternate version is you are not to consider the co-defendant's, whatever it is, conviction is evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of, charges or something. I don't know what that language is, but any preference as to which of those two the court uses? No, nobody cares. Okay.
I don't want either one, sorry.
Clea, I don't
Well,
want either one. And I'd
I'm
like to-
definitely going to give one or the other of them, because if I don't give one or the other of those, then it will be reversible error in the event that there ever is a conviction in this case, which of course would be ultimately a benefit to your clients to build in reversible error. But I would prefer not to do that, because the court's job, to the extent I can, is to avoid any error at all, much less reversible error. So I'm going to give one or the other versions of that language. Does anybody have a preference as to which version of that language the court will give?
Your Honor, can we, since I have a preference, still maintain my objection? I don't think it's reversible error if you keep out these pieces of evidence, and that would be my preference.
No, I don't think so either, but that's also not fair to the other side.
Can we just huddle for a minute
Mhm.
so we may have
And
a split?
y'all don't have to tell me right this instant. I just need to know before the conviction is going to get introduced, which may be sometime today. Okay.
And if they're huddling now, once they're finished huddling, we just have another announcement to the court.
All right. How about announce, and then if they want to huddle, they can huddle.
And good morning, Your Honor.
Good morning.
The state does intend to call Mr. Lee this morning.
Okay.
He will probably be our 3rd witness this
All
morning. I know we were, Miss Abbasi and I were supposed to speak very briefly. After they're huddling, we can have just 2 minutes to speak.
Well, I may have them huddle later,
Okay.
because the Winnie Lee stuff's more pressing, because you can tender the conviction, in any order.
Yes, Your Honor.
So on the Winnie Lee evidence, is there any objection that still needs to get hashed out?
Yes, Your Honor.
All right. Okay, and then if so, where's the easiest place for me to find the
Your Honor,
evidence?
if I may, there's something we wanted to address first.
Okay.
All right, sorry about that. Y'all had to step away for a second. Outcast podcast.
Some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides, that we were not going to be objecting and not asking this court to litigate Mr.
Sound
Mitchell's
sucks
Instagram
today.
reference, because the state was going to call him. Yes, with them coming in, there were portions that we intended to use, with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him. And I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record. But if Mr. Mitchell is not testifying, then we feel we have no option but to ask for a mistrial.
Would the state like to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talking to the mic, pick one up maybe.
the state after the lunch hour indicated to the court, as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it was an either or is what the understanding was. It was we were going to maybe call either Mr. Uten or Mr. Mitchell. And yesterday we decided neither. So I don't know how there could be a confrontation issue that's being claimed today. If we decided to put Mr. Uten up yesterday and not Mr. Mitchell, the records would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well. And
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was at or right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, you know, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody. And then we just went on with the trial, and they didn't, you know, after lunch, they went back because y'all had made that determination, and you certainly communicated that to the deputies with regard to transport. And you are making the representation that you also let the defense know that. Do y'all disagree that the state let y'all know they didn't intend to call either witness?
Excuse me. At the very end of the day, I had inquired to the court to, you know, discuss what's going to be the order tomorrow. And I
Right.
said, well, Mr. Mitchell, Mr. Uten, checking, Mr. Kokomo took a look, and before lunch, what was represented to the court said, you know, who are we going to get to? And they said, we may not get to him today. So
That was before lunch.
that was before lunch, and then we came back in and everything was published.
And everybody I mean, not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back, he didn't want to speak with us, that's fine. We went separately from the state.
Right.
We didn't discuss anything with the state about who would or wouldn't be called at the lunch. And I don't believe before we started in the afternoon. That's not my memory. The announcement before lunch was we may not reach him today. They spoke with him. Obviously, at the end of the day, I still thought they would be called.
my recollection is after lunch, I was sitting there, Ms. Abbasi said, so you're not calling Mitchell? And I said, no, we are not calling Mitchell. That's my recollection before Mr. Howes began testifying after lunch, and we didn't call Mitchell. And the messages came in unobjected or not objected to, and there's been no conditional admittance of evidence that's been
There
permitted
has not.
or agreed to by any of the parties during the trial of this case, at least the time that I've been here. So it's my indicator, be the state's opinion that any objection to the messages that came in are waived at this point.
Your Honor, our response is, we have difference of memory. That's fine. It is what it is. If the state knows they're not going to call him going into it, I don't think it's fundamentally fair for them to publish and then say, ha, you missed it. I don't think that's good faith. As far as, no, we didn't conditionally admit it, because we've done everything we can, at least for Mr. Ryan, to avoid taking up the court's time. This is what it was. We all agreed. We all understood. So that's how we proceeded. And now here we are, and we're stuck in a position we don't want to be in.
Well, I'm not quite sure what to do with this. I have a representation from Mr. Abadi that the state communicated to defense counsel that they were not intending to call Mr. Mitchell or Mr. Uten, and that was communicated prior to Mr. Hiles' afternoon testimony in which this evidence came in. And Ms. Abbasi, you're saying, well, that it's not my recollection, but I could be wrong. That might be. So
I will not say my memory is perfect. I have no memory of having that conversation after lunch. I'm not going to say, Mr. Abadi's. I can't promise you my memory is 100% accurate. And I'm certainly not getting up and saying that Mr. Abadi's lying. I'm not going to do that. But I have no memory of that conversation at all. And, as I said, I brought up at the end of the day, what's the order of the witnesses? When are Mr. Mitchell and Mr. Uten coming in?
I don't remember that.
I had brought it up when we were asking about witnesses, because I didn't know if the sheriff needed to bring them over. And that's what was coming up.
Are you saying that you on the record asked when Mitchell and no, you didn't?
That was at the very end of the day. We were just
Amongst counsel?
I believe Your Honor was on the bench when we were discussing just who are we getting to tomorrow.
Yeah, I asked who we were getting to tomorrow. I don't recall you saying, when are we getting to Mitchell and Uten?
Well,
I don't recall the two of them being mentioned at all at the end of the day.
I know I asked the state at that point, oh, you're not calling him? No. And at that point, the evidence had already been admitted.
I'm
don't think-
asking you, did you make that statement on the record?
I don't believe so.
I
We can
don't
check the
either.
record, but I don't think so. I think the last statement on the record was, we may not get to them today.
The state
I
being
don't recall
underhanded.
that
once again.
statement on the record or off the record. This is all a surprise to me this morning that now there's some debate about it, because everything I knew post lunch yesterday, although through the sheriff's office, not through the state or the defense, was that a decision had been made and communicated that neither of them was going to be called. I mean, can't really do much else with I don't see a basis for a mistrial. So we need to deal with Wooney Lee's evidence. And y'all are just going to have to communicate or put more things on the record or something if you want to avoid misunderstandings in the future.
That's fine. We'll litigate everything first.
Or just put on the record your understanding.
Yes, Your Honor.
So if the understanding was these will come in if Mitchell testifies, just say, we talked about all of this and we don't have any issue as to, X, Y, and Z. And these things we've agreed are going to come in if Mitchell testifies. And then there'll be a record of it and everybody will know what they're dealing with.
I mean, I guess the state can make the suggestion. I mean, we can call him and the state will have no questions for him, and then defense counsel can cross him if that will solve the issue. But
I mean, at this point, he might have yet again been sent back, even though my staff was making Herculean efforts this morning to try to get him over because somebody wanted him. At the bench, y'all said, nope, that's fine. We don't need him. And by y'all, I mean you, Miss Abbasi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office, they don't need him. I don't know where he is at this point.
And Your Honor, Mr. Kokomo checked at the end of the day, I did inquire for the court, who do we need tomorrow? And gestured over to the door. And then that's when Ms. Love said, we've talked about it and we're not calling.
All right, well then, that's even more of a record against your recollection.
I guess I don't understand. There would not have been any reason for me to ask about whether people were coming from the back after the evidence had already come in if I knew he was appointed to be testifying.
So you're saying you pointed towards the holding cell doors?
Right, asking about witnesses for tomorrow.
All right, well, that is no record upon which to grant a mistrial. So let's get to the Wooney Lee evidence.
Yes, Your Honor. We sent it. Sent the email on yesterday at 9 a.m., Your Honor.
To whom?
Well, you know what? I don't think Ms. Percival is on it, so let me forward it to Ms. Percival. I'm sorry. We're forwarding the
We're
reduced.
just trying to get the whatever evidence we're going to litigate now up.
All the attorneys should have received it yesterday at 9 a.m.
Right, I'm just saying the court doesn't have it.
Yes,
so.
I just forwarded it.
Can counsel approach for a minute, please? Yeah, well, whoever wants to come up.
All right, folks, let me see what was going on here. I had to step away for a second. Apologize for that. My new puppy, who ain't but like 7 weeks old, is going through his everything is wrong stage. Let me see what we got going on here. I do believe a mistrial was in order right there. I do believe the state just did something totally dirty.
Have any issue as to, X, Y, and Z. And these things we've agreed are going to come in if Mitchell testifies, and then there'll be a record of it and everybody will know what they're dealing with.
I mean, I guess the state can make the suggestion. I mean, we can call him and the state will have no questions for him and then defense counsel can cross him
Okay.
if that will solve the issue. But
I mean, at this point, he might have yet again been sent back, even though my staff was making Herculean efforts this morning to try to get him over because somebody wanted him. At the bench, y'all said, nope, that's fine. We don't need him. And by y'all, I mean you, Miss Abassi, said, that's fine. We don't need him. If y'all aren't calling him, fine. So we just communicated to the sheriff's office. They don't need him. I don't know where he is at this point.
And Your Honor, Mr. Kokomo checked at the end of the day. I did inquire for the court, who do we need tomorrow? And gestured over to the door. And then
It
that's
really
when Ms.
behooves
Love
me here
said,
what they're
"Talk about it
doing
in
here.
roll call."
I don't understand it at all.
All right, well then,
This is chaos. I'm on
that's
chaos.
even more of a record.
I'm just trying to
Not given
see
any re-
what happened when they got ready to leave out.
Yes, Your Honor. We sent it.
Now I'm just looking around here and see what's going on. Just trying to figure out what's going on. I hate I had to step away, but I do have to do that once in a while, and I do apologize.
Yes, Your Honor. We sent it.
Let me bump up here a little bit. Let me see when they actually go, what they're going out for. We got a bench conference. Okay, so that's what we're doing. So they're gonna have to figure out how to get past this injustice of not calling this guy after they produced all this evidence.
Who's your next witness going to be? Okay.
I think a mistrial should have been called there. I think that was unhinged and dirty of the state. Very dirty. This is going to get, if this does result in a conviction, you're going to see a massive amount of appeals being filed and won, and a lot of retrials being done if a retrial is even done. It's hard to say right now.
Thank you.
The Outcast podcast here on YouTube, live day 150, the YSL trial. We already had a mistrial declared today. Well, we've already had a person ask for mistrial, which I kind of seen coming.
My name
You
is
get one a
Aldo
day,
K.A.L.
but I got a feeling that
H-O-G-A-N,
Brian Steele is going to get
and I'm a
involved in this
detective with
soon.
Atlanta Police.
good morning. Detective Hogan.
Good morning to you, sir.
Can you tell the court how you are currently employed, sir?
I am a detective with Atlanta Police. Currently, I'm assigned to general investigations out on Fulton Industrial, but prior to that, I was a homicide investigator for about 10 years.
And Detective Hogan, can you tell the jurors how long you have been employed with the City of Atlanta Police Department?
I have been certified police officer since 1987. had a couple of different jobs with the sheriff's departments and with the air marshals. But anyway, I landed in Atlanta about 15 years ago.
And you said you had been a police officer since 1987. Prior to working with the city of Atlanta Police Department, where were you in law enforcement?
I started in the jail in Fayette County, was there for a few months. They put me on the road, was certified then in 1987. I worked as a road deputy in Fayette County. I was promoted to detective, worked undercover narcotics locally, and then I was assigned for a good many years, 10 years or so, to the DEA task force at the Atlanta airport. We did drug interdictions there. In between there, I spent a brief period of time as a federal air marshal. This was before 9/11, and that job wasn't for me, so I came back. And that's when I went on through with DEA, and then eventually landed in Atlanta about 15 years ago.
Now, you a few minutes ago told the jurors that you were assigned with the homicide department for 10 years.
Yes,
And can you tell the jurors, were you assigned with the homicide unit here with the City of Atlanta Police Department back in February of 2019?
I was, yes.
And can you tell the jurors a little bit about, I guess, how you're assigned specifically to any homicide case that you're working here in the City of Atlanta?
It is the luck of the draw. We're all in a rotation. There's a big board in the office. There's about 17 of us that are in the rotation, about 6 of us that work cold cases. At the time, I was in the rotation, and your name is on a magnetic strip with a label on it, and everybody's name's in a row or in a column. As murders occur, the person from the top catches the murders. That he's the lead, he or she's the lead investigator, and they go to the bottom, and everybody moves up. On this particular day, I was at the top.
Okay. And can you tell the jurors on February 23rd of 2019, were you dispatched or called to come out to the location of 50 Mount Zion Road?
Yes, I was.
And can you tell the jurors what was the reason you were dispatched to that location?
There had been a homicide, a criminal homicide. What they suspected to be a criminal homicide, and they asked homicide to come. That's to work the case.
And is that address 50 Mount Zion Road? Is that here in the city of Atlanta, Fulton County?
It is. It's in Southeast Atlanta.
Okay. And when you, I guess, can you tell the jurors, we've heard about different zones that are within the city of Atlanta. Which zone does this location fall within?
Zone 3.
Okay. And the zone 3, does that include the area of like Cleveland Avenue?
It does, yes.
Okay. Now, can you tell the jurors when you arrived to the incident location, can you kind of describe for them what kind of property it was? Was it a business? Was it a residential location?
It's an apartment complex.
Okay. And were you the first to arrive on scene?
No, sir.
Can you tell the jurors? Now, with not being the first to arrive and being, I guess, assigned as the lead detective because you're number 1 in the rotation, can you tell the jurors a little bit about the first things that you do when you interact with other first responders who arrive before you, other officers and detectives?
Sure. So they, just by the act of being there and doing their job, they've gathered some information that may be interesting to me or help me with my investigation. So of course, I get there, observe how things are laid out. They have delineated the crime scene and what they think the crime scene is. So they mark that out with yellow tape, trying to make that a pretty big area. This particular one was a fairly big crime scene. So I could see that when I pull in, and then I speak with the 2 officers that are watching the crime scene log. I speak with the general investigator who has started the crime scene drawing. I talk with the ID technicians that are there that are, and I assist them and make sure that any evidence that I see on the scene that I'm interested in or like for them to gather or document, I make sure they do that. And I just try to glean as much information from what they have uh, from them so I can help me further my investigation.
Now, after speaking with other members of law enforcement who were on scene before you, can you kind of describe, I guess, the layout? You said that this was an apartment complex or a residential complex. A little bit about the layout of the complex as you first observed it when you arrived.
Yeah, it's a large complex. It's in two phases. There's a Mount Zion Road. Obviously, it faces Mount Zion. The address is 50 Mount Zion. Then there's a phase, I'll call it phase one, which is in the front that's up closest to Mount Zion. There's a creek that runs behind that phase one is a creek. So there's a bridge and an access road down one side of it. I think it's the east side of the property that goes past over the creek. And then there's a large recreational area, a big grass field, and then a playground for kids. And then the second phase is in the back, but there's only one way in and out to get to the second phase. And it's in the back of the property across the creek. This crime scene encompassed all of the access road to get to the phase two, and all the way up into a pretty good portion of phase two where the road runs up into the parking lots, the access into the buildings in the phase two.
So in a second, Detective Hogan, we're going to put up State's Exhibit 11 NN, which was previously admitted into evidence.
Yes, sir.
Can you see it on the screen?
I do.
Okay, so do you see at the top of State's Exhibit 11 NN, there's, I guess, a red line that's drawn. It's right by where the time is, where it says 9:33 a.m.
Right there, you're talking about?
Yes. Can you tell the jurors, is that building that you can kind of barely see at the top of State's Exhibit 11 NN, is that the first phase or the first building of the complex?
That's correct, yes.
And then do you see in the middle of State's Exhibit 11 NN, it looks like something, looks like a brown kind of something that's separating the grass in the middle of State's Exhibit 11 NN?
Right here.
So in the middle of State's Exhibit 11 NN, you see trees, and there's this.
Oh, that's the creek. There's the bridge.
And then it's the area you described, I guess, where the playground and things, the recreation area.
It's under here, under the trees, back over here in this area.
Okay, so it's towards the, I guess, the left side, kind of middle of State's Exhibit 11 NN.
That's correct, yes, sir.
Okay, now you described to the jurors briefly about the second phase or the second half of the apartment complex. Do you see that phase in a State's Exhibit 11 NN?
I do. It's this phase here.
Okay. And can you tell the jurors?
Here we go.
What areas in State's Exhibit 11, and if you can see it, I guess, were pertinent to your investigation in relation to the crime scene?
Immediately when I pulled up, I parked in the parking lot up here. If you can imagine, the phase goes up Mount Zion Road would be up here. I parked my car outside the crime scene and walked in. I checked in with the crime scene technician. Immediately, I could see that there was a blue car resting against the fence, and I think there was a big rock that it ran into right here, where there was some stuff on the ground and stuff on the car. And as I walked up, of course, that's going to be pretty interesting. It's not supposed to be there. So as I walked up, I saw that it was part of the crime scene. There was blood in the passenger seat. There were bullet holes in the car. There were shell casings on top of the car. Items of clothing were on the ground and on top of the car. And then as I walked further past, I could see there were some tire tracks that were through the grass here, beside the building here, as well as more shell casings that were kind of scattered out in this area over here. And then they had crime scene tape stretched out across here and across there to deny any access into the crime scene.
Now, you talked about crime scene tape and things of that nature. When you arrived, had the crime scene been fully secured?
Yes.
Okay, can you tell the jurors a little bit about how that's done and why that's done?
Yeah, well, we're trying to preserve evidence. Everything in there may have something of value to us that we could use to further investigation. So obviously, we don't want anybody to tamper that either on purpose or by accident. So we try to protect it. We try to make it as big as the officers that responded made it as big as they thought they needed to protect everything that I just described to you. The shell casings are easily kicked or moved. We don't want to touch anything that may have DNA or fingerprint evidence on it. There's just lots of things we need to try to protect so we don't damage our own investigation.
And Your Honor, can I approach the witness?
Yes, you may.
I want to show you what's been marked as State's Exhibits 48 NN through 67 NN. If you'll just flip through those, have you had an opportunity to go through those prior to your testimony here today?
I've seen them before, yes.
And as you're flipping through them, I guess, what are State's Exhibits 48 NN through 67 NN?
These are all crime scene photographs from the scene.
And do the photographs in State's Exhibits 48 NN through 67 NN fairly and accurately depict the crime scene, 50 Mount Zion Road, when you arrived on February 23rd of 2019?
Yes.
Around at this time, the state would tender what's been marked as State's Exhibit 48 NN through 67 NN.
Those are admitted.
Now, you talked about the area of, I guess, where you said it was a blue vehicle,
Yes.
and in your investigations, did you determine what type of vehicle it was?
I do. It was let me look at my notes here for the year model, but it was a Dodge Charger.
Is looking at your report
Yes.
help refresh your recollection?
Say again?
Is reviewing your report, will that assist you in the refreshing?
Yes, I'm just trying to get a 2014 Dodge Charger.
Okay. And can you tell the jurors, when you arrived and began to investigate and look around the Dodge Charger, was it occupied? Was there anybody in it?
No, sir.
Okay. Can you tell the jurors, you talked about the tire marks that you had seen. Can you describe the condition of the vehicle as you began to investigate and process the vehicle?
Well, we had run the tag, or somebody run the tag, and it came back stolen out of Cobb County. It did have some defects in it. It had several, which appeared to be bullet holes to me, from my experience. And there were 12 of them total. Again, there was a large amount of blood in the passenger seat, front passenger seat, and some clothing. A baseball hat was on top of the car. There was a projectile that fell out of the hat when we picked it up. And then there was, other items inside the car that were gathered and
Okay.
documented.
And in a second, Ms. Knight is going to put up State's Exhibit 15 NN, which has been previously admitted into evidence.
Mhm.
Actually, okay, my apologies, 16 NN. And in 16 NN, Detective Hogan, can you kind of point out for the jurors the areas in which you just described as defects? I think you said 12 in the Dodge Charger.
Yep. You can look pretty close. You can see whatever's kind of out of place. In this particular image, my memory serves right. This white is a defect. You can see the different ones that stand out pretty readily, and you can see why I'm assuming they're bullet holes. But in that particular picture, I see four defects.
Okay. And you said that around the car, was there, I guess, ballistic evidence also located, I guess, on the car and surrounding it?
Yes, there were shell casings. Off the top of my head, I don't remember how many, but there was 2 or 3 on top of the car. I think maybe that's what that is. But there was up here were spent shell casings. They'd been fired and ejected out of the gun and landed on top of the car.
And can you,
Objection, Your Honor, that's speculation.
Sustained.
well, you said they were spent shell casings. How did you know that they were spent?
They didn't have a bullet in them anymore.
Okay. Now, can you tell the jurors, as you're kind of walking around and observing and processing the scene, are you being assisted by members of the Atlanta Police Department's crime scene tech unit?
Yes, and if they were there before me, and they started working the crime scene, so they were really very familiar. They showed me a lot of stuff, and then I just went in behind them and made sure that everything they showed me I was interested in, and make sure that if there's anything that I saw they didn't know about, make sure they knew about it to gather it.
And can you tell the jurors, as it relates to your working in conjunction with the crime scene techs that were present that early morning, what type of shell casing do you remember was identified as the shell casings found around the car and in the general area?
On the car, and then a little further up on the crime scene, they were all smaller caliber shell cases, like 9mm.
Okay.
Later on, we did find some 7.62 as well, some larger caliber.
And you said around the car, and then I guess a little bit further up from the car. I'm going to show you what's been admitted as State Exhibit 52NN. Can you tell the jurors when it comes up what to your recollection, the yellow placards in this photo are marking or representing?
Sure. You can barely see them on this one, but there's a little yellow square there, and another one up around the corner. Those are placards. They have numbers on them. ID techs, when they document stuff, they document right where it says. So they put the placards up next to or adjacent to the pieces of evidence, and then take pictures and document where they found it. Later on, after they do that, then they'll gather that, and it'll be delineated on their report by that number.
Well, on crime sound sucks today.
But this, if you can imagine, if you were in this picture, if you turned around directly 180 degrees, that's access road that goes out to the front of the property, and then the blue car is down right behind you.
Now, if you are looking at the right side of State Exhibit 52NN, and it looks like a raindrop that reflected off from the photo, if you see where there's a vehicle or a red car kind of in the middle, right-hand side of State Exhibit 52NN?
Yes.
Can you tell the jurors, if you continue to go straight down the access road and take a right where that red vehicle is, can you tell them where would that take you?
That takes you into the parking lot in between 2 of the buildings in the complex.
Okay. And is that the buildings that I guess would be the front buildings, the first one we saw that was closest to Mount Zion Road, or the back set of buildings?
That's right.
That's what?
The back set,
Backside. Okay.
phase 2.
Now, you reference or talk to the jurors a little bit about the fact that there were additional shell casings that were found in a different area in relation to the vehicle.
That's correct.
can you kind of describe for the jurors? I'm going to show you what's been previously admitted into evidence as State's Exhibit 10NN. And using State's Exhibit 10NN, Detective Hogan, can you kind of orient the jurors as to the area that you described that you found the second set of shell casings?
Sure. Well, I told you about the shell cases that were on top of the car. Those were 9mm. There were several more that were scattered around in the roadway and the grass over here in this area. And then there were several that were found in the grass. These are the larger caliber shell casings over here. Over here at the corner of the building and around and on top of the car were the 9mm. The larger caliber 7.62 were in this area.
And if you can recall, in that area that you just kind of described and oriented the jurors to, where the second set of shell casings you found, how many did you find? Looking at your report will refresh your recollection.
Yeah, let me look and see.
Just
I don't remember.
if and when your recollection is refreshed, just look up and I'll re-ask you the question. If it helps, I can direct you to maybe page 4.
Yeah, if you would, because it's not jumping out at me.
Yeah, if you look to page 4 of your report, and if that helps refresh your recollection towards the bottom.
Oh, 15. Thank you.
All right.
15 7.262 caliber shell casings.
So it sounds like after looking at page 4 of your report, your recollection's refreshed?
It is refreshed.
Okay. And you described them to be a larger type of, or larger caliber of ballistics or shell casings. Can you describe to the jurors a little bit about that?
Sure. Well, a handgun is a smaller caliber, usually somewhat smaller caliber. Police carry 9mm or 40 calibers. Each caliber is a different size. So each shell casing is going to be a different size to accommodate whatever size bullet it shoots. For example, the 9mm the bullets are about as big approximately as into your pinky finger. So the shell casing has to be the size for that to fit in. A 7.62 is normally associated with a long rifle, like an assault rifle. And it's a much bigger bullet. It has a lot more gunpowder behind it. It shoots a lot faster and longer. So the shell casing for that is going to be larger and distinctive for that caliber of weapon.
And based on your investigation, is it, or based on what you saw and observed, were, I guess, all of the shell casings that you saw was larger, the 7.62, kind of grouped in one area?
Yes,
And
they were all
then
found in one area.
the shell casings that you described earlier, a few minutes ago, that you said were smaller caliber or 9mm, were those all kind of grouped within, one small area, separate and distinct from the 7.62?
The majority of the shell casings, the 9mm were discovered here. The only exception to those would be the ones that were found on top of the vehicle when it was abandoned.
Now, can you tell the jurors, do you see the red line that kind of travels throughout State Exhibit 10NN?
The long one?
Yes.
Yes.
Can you tell the jurors, based on the investigation at that point, the shell casings that you had found in different areas and the tire marks that you described, why, I guess, that red line is there and what it represents.
For me, that was, I created this, so, and that was pretty rudimentary, but I'm not a computer guy. The little red dots it's not accurate, but it just indicates where the shell casings were found. This was a line based on my investigation of where the victim said they had parked. And this is the access that they took trying to get out when the shooting broke out. So there was a shooter that came out here when it started shooting. They drove out. Another shooter down here drove past, walked, well, you can see the tire tracks in the grass. Drove off the road, back on the road. Car was not functioning, so they rolled to a stop here in the next. It's just a line to kind of show where I thought they went when the incident happened.
And I'm going to show you what's been marked and tendered and admitted into evidence. It states that it's 59 NN. And in this photo, do you see kind of the grouping of the yellow placards that are seen within states of it 59 NN?
Yeah, same procedure as what I described earlier. Where there is a shell casing, they put a placard, and next to it is a corresponding number that indicates that particular shell casing. This is coming out from the Rick Breezeway, and this is where they, all the different placards indicate the different shell casings that were found.
And do you see kind of in the middle of State's Exhibit 59 and then towards the, I guess, the breezeway? Let's see if we can get this up your way. In this area right here?
Yes.
Are those placards, are they also the larger caliber shell casings?
Bluetooth disconnected.
Okay.
Caliber.
And
Bluetooth connected.
are photographs taken of each placard from, you know, a far away distance or a full range distance, mid range, and then close up?
Yes.
Okay. To your recollection, was that done in this case?
I wasn't present, but I'm assuming they do it the same way every time.
Okay. And for time and efficiency, is that what we see in State's Exhibit 60 NN through 67 NN?
Yes.
Okay. Now, after you
Bluetooth disconnected.
completed kind of walking through the scene,
Bluetooth connected.
members of the City of Atlanta's crime scene unit, while on scene, did you get information that two males had contacted 911 indicating they had witnessed what happened at 50 Mount Zion Road?
I did.
Okay. And I don't want you to tell me what anyone said as I go through the next questions. As a result of that, did you go to APD headquarters just down the street here off of Peachtree?
Yes.
Okay. And can you tell the jurors when you arrived, did you speak to the two males?
I did.
And without telling me what they said, can you tell the jurors who you spoke to that early morning?
Sure, is Bernard Mitchell and Rodney Uten.
Okay. And can you explain to the jurors, without telling me what they said, kind of the circumstances and of the setup of the interview? Let's start with that.
Oh, it was just an interview. Well, there's two different areas at headquarters that we speak to people in. One's the interview room. It's just like if you guys came in and had something to tell us, we put you in an interview room and we speak with you. The other is what they call an interrogation, or when they're in custody. In those rooms, you're secured, chained to the floor, and both rooms are audio and video recorded. Both types of rooms.
And you said they were in the first room, the interview room that you described?
They were in, oh, yes. the
And-
witness room.
Can you tell the jurors, do you interview them together or do you interview them separately?
They were done separately, at different times, same, one after the other.
And after speaking with both Mr. Uten and Mr. Mitchell, can you tell the jurors, do you speak with a female, Miss M. Smith, after speaking with both Mr. Mitchell and Mr. Uten?
That's correct, yes.
And can you tell the jurors, do you speak with her that same day, later on February 23rd of 2019, or at a later date?
It was on the same day, on the 23rd.
Okay. And can you kind of explain to the jurors in relation to when you arrived to the scene and kind of worked and processed the scene with members of the police department, about how long after you arrived did you begin to interview people in relation to your investigation?
Multiple times in the report. It all came together fairly quickly once it started rolling. Let me see if I notated it in my report. Do you know specifically in the report where I need to be looking?
Let me ask you generally this question based on your recollection. Was it a matter of hours that you began speaking with witnesses, for example, Mr. Uten and Mr. Mitchell?
It was all in the morning time. Yeah, it was like 6 in the morning when I got to the crime scene. It was well before lunch when I was talking to Mr. Mitchell and Mr. Uten.
Okay. And when you spoke to Miss Smith, can you tell the jurors kind of the setup or the arrangement for that interview?
That was in the witness area. It was later on in the day. I think it was after lunch, thereabouts. But same, voluntary. She came in and I spoke with her.
And when you're speaking with Miss Smith, is it just you and Miss Smith, or are there any other members of your team that are also present?
Detective Casey was with me.
Okay. And can you tell the jurors, as you began the interview with
You're talking about Mariah, right? With Miss Smith, or with the other two?
So I'm talking about Miss Smith.
Okay, yeah, Miss Smith.
Yes.
Detective Casey was with me. Yes.
Yes. So can you tell the jurors, when you began the interview with Miss Smith, can you kind of describe for the jurors her general demeanor that early morning?
Sure. Yeah, she was upset, nervous, crying, young girl, and you can imagine. She said she was a witness to a shooting and a murder, and she was upset.
Now, as you began the interview, can you tell the jurors, how did you start?
Sure. Well, I started all the same way. I introduced myself, and we start talking about, and I asked, talking about the situation that they witnessed, and I asked for their statement. And she began by telling me a series of events that she relayed to me at that time that I knew were not to be correct based on what I knew from the crime scene.
Okay. And when you say knew what not to be correct in relation to the crime scene, can you explain to the jurors, I guess, what you mean by that?
Yeah, she was saying that this victim had been shot by one of his companions. The way she described it, it was not possible based on what I knew from the crime scene. So I brought that to her attention. After some consoling and some speaking with her by me, she realized that she changed the story to what the truth was, which we knew that she was not telling the truth.
Okay. And as you continued, I guess, to confront her with the physical evidence
how can you not
that
object to
you
that? I mean, hold
had
on.
located on the scene, and
Whoa, 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 whoa. The guy just said on the stand that he knew she wasn't telling the truth, and nobody objected. What the hell? I mean, really, what in the teetotal? What's going on here? Oh, I don't know.
Through your investigation while on scene, did she provide you with um, names or nicknames of individuals she knew to be involved?
Yes, she did.
Okay, and do you recall, or can you tell the jurors the nicknames that she told you of the people she saw shooting that night?
Yes.
And if referring to your report would help refresh your recollection, by all means.
One was Little Rod and Bali.
Okay. And can you tell the jurors, as she described what she saw, um, did she tell you, or tell the jurors what she told you about the firearms that she saw Little Rod and Bali having?
Judge, Your Honor, I'm going to object that this is improper bolstering. She's already testified to this.
This is impeachment, Your Honor. She testified she couldn't recall at times during her testimony as it related to the firearms, what they look like.
All right, here we go. Back to a bench conference. Sidebar in progress here as they are now. He's trying to impeach a witness with another witness, which happens all the time. But let's go back to this witness. I believe his name was Mitchell. That was supposed to be coming in today for this defense to be able to question because evidence came in yesterday about this person and is coming in again this morning, as you can plainly see. And the state decides, oh, we're not going to call this person, but they've already presented the evidence through another witness under the assumption that they were going to call this witness in, which puts the defense at a huge disadvantage. I'm really looking for either Max Shart or Brian Steele or Doug Weinstein or his boss, Jay Abbott, to file a big motion for mistrial, a very detailed motion for mistrial. I think they need to sit down and they need to go day by day and just put it all into one huge motion and present it from day 1 to day 150. Put everything into a motion and put it in front of the judge and be like, this has to stop. Make that huge record and then go ahead and go straight to the Supreme Court of Georgia and be like, hey, it's time for you guys to step in and stop this. Because it's obvious this judge is just going to continuously allow improper testimony, improper evidence to get in.
You you've been describing the fact that the first part of the interview you had with Ms. Smith, she gave you a number of facts and scenarios that were not aligned with what you knew to be consistent with your investigation of the crime scene, correct?
That's correct.
And as your interview with Ms. Smith continued, I believe you indicated earlier about the statements that.
One more quick question. Where's Love? Where's Hilton? Where are they? Inquiring minds want to know because those two have royally messed this trial up. Maybe Fonnie Willis is finally getting her crap together. She's going to lose re-election. Two other YouTubers with massive following have both stated they did not vote for her. They've already early voted. One of them said they voted for Trump. I don't care who you vote for. That's up to you. The point is, Fonnie Willis has fried herself. And this case is one of the cases that fried her because the other DA would not even entertain prosecuting this because he knew it was a waste of time. Fonnie Willis says, oh, I can go after this big time rapper and take him down and bolster my career, no.
that Miss Smith made going forward about what she observed on that early morning of February 23rd of 2019 as it related to the shooting. The facts that she relayed to you after you confronted her with what you knew to be true about the physical evidence on the crime scene, the facts that she was giving you, did they become consistent with what you knew through your investigation at the crime scene?
They did become consistent, yes.
Okay. And as you continued to interview Miss Smith, did she continue to provide you statements as it related to what she saw and heard that were consistent with what you've described to this?
Ruled based on our discussion at the bench.
So let me see if I can remember what I was asking you. So as she continued to describe things that she saw and heard and observed on the crime scene that early morning when the shooting was occurring, were those statements consistent with what you knew that you found on the crime scene earlier during your investigation?
Yes, sir.
Okay. Now, can you tell the jurors, we talked a little bit about, she was able to provide nicknames. Can you tell the jurors, without telling me what she told you, but was she able to provide you with Instagram handles or usernames for the two people she gave you nicknames for?
Yes.
Okay. And as a result, I guess in conjunction with that, was she actually able to pull them up and show you photographs as it related to the person she knew as Little Rod?
Yes.
Okay, and I want to show you what's already been admitted into evidence as State's Exhibit 23NN and 24NN. While she's pulling it up, I will give you a physical copy so you can see it.
Oh, yeah.
And while Ms. Knight is pulling it up, if we can get the technology to work, are those the photographs that Ms. Smith was able to provide you in relation to the person she knew to be Little Rod?
That's correct, yes.
And can you tell the jurors, do you see her signature on those photographs?
I do.
Don't pull it up. And can you tell the jurors what date is her signature on those two photographs?
The 24th of February of 19.
Okay. And was Ms. Smith able to do the same thing as it relates to the person she knew to be Mr. Bali?
Yes.
Okay. Now, can you tell the jurors, after receiving this information from Ms. Smith as it related to who she saw shooting, can you tell the jurors, were you able to determine the identity of the people she knew to be Bali and Little Rod?
Yes.
Okay, and who were those people?
Little Rod's name is Rodelius Ryan Jr. Bali's name is Damon Blaylock.
And let's see. Now, before we move on from Ms. Smith's interview, can you explain to the jurors, so during Ms. Smith's interview, you described how you confronted her with the physical evidence as it relates to the statement she made initially at the beginning of the interview. You remember that?
Yes, sir.
And can you tell the jurors, when you confronted Ms. Smith with the fact that what she was saying didn't make sense with what you already knew, did you tell her the identities of the people who were shooting?
No,
Did you, before speaking to Ms. Smith, have any idea who they were?
I didn't know him from a can of paint. No, sir.
And was that something she was able to tell you based on what she described as what she saw and heard that early morning on February 23rd of 2019?
That's correct. Yep.
And while you were interviewing Ms. Smith, did you provide her with any facts as it related to the identities of Mr. Ryan or Mr. Blaylock during that interview?
No, sir.
Okay, and was that information that she was able to provide, or did she provide you information that assisted in your investigation in identifying both Little Rod and Mr. Blaylock?
That's correct.
Now, after speaking with Ms. Smith, can you tell the jurors, did you attempt to identify another female described to you during Ms. Smith's interview?
Yes.
And can you tell the jurors who was that?
Her nickname was Brazy. She was with Miss Smith.
And if, your report.
Tyhera Hartfield. Oh, excuse me, that's her mom. Oh, yeah, Tyhera Hartfield. That's right.
So it sounds like using your report refreshed your recollections?
Yes.
Okay. And in your identifying Ms. Hartfield, can you tell the jurors, based on your investigation into Ms. Hartfield, what her living situation was?
She was a runaway, listed as a runaway at the time.
And ultimately, before, let me ask you this question. Based on the information that you've talked about here today, can you tell the jurors, did you make charging decisions?
I did.
Okay. And can you tell the jurors, did you swear out warrants for the arrest of Mr. Ryan and Mr. Blaylock?
Eventually, I did, yes.
Okay. And can you tell the jurors, did you ultimately get to speak with Ms. Hartfield?
I did.
Okay. And without telling me what she said, did you, I guess, speak or interview her in a similar fashion that you've described as it relates to Mr. Mitchell, Mr. Uten, and Ms. Smith?
Yes.
Okay. And during your investigation, can you tell the jurors, did you also receive a social media posting as it related to Mr. Ryan hours after the homicide?
Yes.
Okay. And was that something that you used and utilized in your investigation in taking out the warrants that you've described?
Yes.
One moment. I don't have any further questions pending redirect.
All right, are there defense questions for this witness?
There are, I do want to make sure I can get a hold of at least one of these snippets.
Okay.
Good morning, Detective.
Good morning.
Coming into today, have you had a chance to review the interviews you did with the witnesses you spoke to?
Not all of them, but yes.
Okay. You haven't had a chance to review them?
I haven't reviewed, I reviewed Mr. Mitchell and Mr. Uten's recently. The others have not.
Okay. All right. So I want to start. You've been an officer for quite a while, yes?
Yes,
And so you know that when you are getting information from people, it is of the utmost importance to make sure it's accurate, right?
yes,
And that's one thing you were doing with Ms. Smith, is confronting her with facts to test whether what she was saying was accurate, correct?
that's correct.
All right. And especially in a situation kind of with young people, they may not always be fully forthcoming in the beginning, correct?
It's not limited to young people, but yes.
Right. Especially if they think there's something they could get in trouble for, correct?
Yes,
All right. And the folks that you were speaking with in this situation, they were not, well, the two young men you spoke with, they were not lawfully allowed to have weapons, were they?
no, I don't think so.
Okay. So that's something they theoretically could get in trouble for if they admitted to it.
Yes,
Okay. So when you're speaking with them, when you're speaking with Ms. Smith, you're asking questions to make sure you can verify things. One of the things you told Mr. Mitchell you would do was get his Instagram records, correct?
I may have, that doesn't come to mind off the top of my head, but it would be something I would do, but I don't remember if I told him that. or
Would
not.
it help refresh your recollection to see a copy of a transcript from that interview?
Sure, yeah.
One moment. Here we go. All right. I'm going to direct your attention to page 19 here. If you could quietly read that to yourself. Let me know when you've had a chance to refresh your recollection from that.
Your Honor, before he answers the question, I'm going to object to hearsay what Mr. Posey said during the interview to anyone would be hearsay.
He's-
Out of court statement.
He's on the stand. He can repeat what he said.
That doesn't make it not hearsay, but
And I can ask whether he asked somebody.
yeah, I think it's not hearsay in this circumstance, so overruled.
I mean, in this circumstance, it would be being,
That's overruled,
Okay.
so.
so were you planning on getting Mr. Mitchell's Instagram records?
I may have been. It's hard to say. This is a lot of years ago, so it's part of my tools that I use for in each or any case that I have that I work. If there's an opportunity to pull those, and I need those, then yes. But I don't remember if I wrote a warrant for his Instagram or not.
Okay. You said if you have the opportunity, you certainly had the opportunity, right?
Yes,
Okay. And with those, if you had them, you could come back to him and say, hey, was this true? Was this not true from what you told me, correct?
yes, I could. Yeah,
Okay. And Mr. Mitchell and Mr. Uten, they were both cooperative, correct?
yes,
So if you wanted to follow up with them, they gave you no indication that they wouldn't speak to you or anything like that. They were readily available.
yes. Not at the time they were cooperating with me that day. Yes.
You didn't attempt to contact them any other times, though, did you?
I don't recall doing so, no.
Okay. So in this case, do you recall what search warrants you did take out?
No, not all of them, no.
Okay. Do you recall taking out warrants for Instagram records?
I do.
Do you recall whose records you requested?
I know I got little rods, I got valleys. And without going through the index on my report, I can't tell you exactly, but I know I got little rods and I got valleys. I got Rodelius Ryans and I got Damon Blaylock's. May have gotten Mariah's and Brazy's as well, the Tyara Hartfield and Ms. Smith.
Okay. What was your purpose in getting those records?
As to any information there that might help with the investigation.
Okay. Did you look at those records?
Not personally, no. I looked at some of the pictures. It comes in a format. Again, as I indicated, I'm not a computer guy. I'm not even on social media. I gave that information to somebody who could put it in a format that was easier to read, and then those people looked through it and they let me know what they found.
So it wasn't for you to get more information. Someone else was supposed to get more
The
information.
information is going to come to me. It just didn't come through me.
So at what point did you get the information of what was contained in those Instagram messages?
When they gave it to me, I don't know what day it was.
Who's they?
I don't remember who the analyst was that did the examination of those records.
Okay. And the examination of those records, I would assume you included in your report?
Some of them, yes.
Some of them. Could you let me know then when? I assume if you put them in your report, it says then when you got them, correct?
It says when I put it in the report. Let me see.
I mean, that's something you would put in the report, right?
One that jumps out at me was from February the 26th of 2019. Somebody sent me an Instagram post on that day, and it was a short video that showed Mr. Ryan riding in a car.
Okay, but that's not the Instagram records, right?
It's from Instagram.
That's not the Instagram records for which you obtained a search warrant to get so you could get more information, correct?
I haven't verified it, but if it came from his Instagram and I got a search warrant for his Instagram, then yes, it would be in there. I
Right.
just got it before I got the search warrant records back.
I'm sorry, if you could
It was
repeat that last
posted.
part.
It was posted. Somebody saw it. They sent it to me. If my search warrant had not been executed and the information sent back to me at that time, it would be included in both records, but I got it before the search warrant records came in because somebody sent it to me right after it was posted.
Okay, I think a second ago, because you said you didn't confirm it, right?
You're going to have to, I don't understand what you're saying. I've confirmed it. Yeah, what are you talking about?
Well, I think about the content of the messages, you said you did not confirm with the records.
I just said I'm assuming
Right.
if it's in his Instagram records, I received it before the records came back from the search warrant. I'm assuming that that information that I received that day before the records came back would be in the records when they arrived to me.
Okay. So without those records, having looked at them, there was no way for you to go to Ms. Smith or Mr. Mitchell or anyone else and say, hey, you told me X, Y, Z, but your records say something completely different. Right?
I did not do that. No.
Okay. You could have done it though, right?
Yeah, sure.
And that would have been confirming, right?
Sure, yes.
I want to ask you about what you testified to earlier about the actual crime scene. Mr. Abadi asked you questions about where you found certain things. Do you remember that?
Yes,
And you answered questions about where you found those 7.62 shell casings, right?
yes.
But you didn't actually find those casings, did you?
No, I did not.
Those photos, you weren't there when they were taken, right?
No,
You never saw where those 7.62 casings were.
not physically, no.
So when you say you found them, you didn't find them. Someone else did.
I said they were found. I'm not sure that I said I did.
Okay. When did you learn about those casings?
Later on the same day that the murder happened, I was at the office when I got the call.
Okay. And when you spoke with Mr. Mitchell and Mr. Uten, were you aware of those casings?
As I recall, it was around the same time. I don't remember exactly the sequence of events. But I spoke with them later on in the morning. It was sometime around the same, a lot of things were happening at the same time, that we got the call about the shell cases. That's one of the reasons I did not physically see them, because I was busy at the office. So I asked the responding officer to collect them and supervise that. But I don't remember the sequence of when exactly they came in.
Okay. Would it help refresh your recollection to see a copy from your trial testimony?
Sure.
I'm sorry, not your trial testimony, the last proceeding, several proceedings ago.
Okay, sure.
All right, I'm going to direct your attention to page 1076 from the prior hearing. Also turn to page 1078 if that's helpful as well.
Day 150 of the YSL RICO trial in Georgia versus Jeffrey Williams et al. We started out today with mistrial madness, call by the young lady here right now. They were supposed to be bringing this Mr. Mitchell back in for a testimony for after some evidence got presented yesterday during testimony. They were supposed to bring him back in. Well, after they got that evidence in, the state said, no, we're not bringing them in here now. We've got our evidence in. And so a mistrial was asked for this morning. The state then said, well, we'll bring him in for testimony. We want to ask any questions and we will let the defense do what they want to do. That's not the point. You gave all indications that you were going to bring this person in and then you decide not to. That's dirty pool.
All right. So what's your question again?
If when you spoke with Mr. Mitchell and Mr. Uten, you were aware of the 7.62 shell casings.
I was aware that they described to me two shooters, but I don't recall if I knew about the shell cases at that time. I may have, I don't remember.
You said that they described to you two shooters?
Yes,
Okay. You've got a transcript in front of you, so you've testified about this before, correct? This matter?
yes.
Okay. And you don't recall the attorneys asking you at length whether anyone besides Ms. Smith mentioned two shooters?
I read here that they were asking me about that, yes.
Okay. And your testimony was that Ms. Smith was the only person who said there was 2 shooters, right?
Yes. That's what it says here.
I mean, when you,
Wait, before we get too far around here, let's make sure we got the right context.
if you want to flip to page 1,100.
No, let me read these first.
Okay.
Talking about context. He knows he's been busted. He knows he's been caught lying, and now he's got to context it. How many witnesses have been caught lying on the stand, and the judge has done
Page
nothing?
1076, as I recall, they were asking me about my interview with Ms. Mitchell. And I had mentioned to her that I had 2 sets of shell casings. They were trying to determine if she.
Okay, well, I don't need you to testify
Yeah,
about what someone else
what-
was trying to do.
So what I'm saying is context matters. In this particular instance, I was describing my interview with her, and in the process of the interview, when I was confronting her with the evidence, I told her that I had 2 sets of shell casings.
Yes, I understand that.
You said page 1100?
Yes, sir.
Okay.
So having reviewed that page, Mariah was the only person who said there was 2 shooters, right?
According to that transcript, yes, ma'am.
That was your sworn testimony under oath, right?
That's what I said. Yes, yes, yes.
All right, so that was the truth that you said it then, right?
Yes.
And I'm going to back up for a moment. I think you said Mr. Mitchell and Uten, they told you about not 7.62, but a weapon which would have fired larger shells. Is that right?
Yeah, they described a long gun coming out of the breezeway. Yes.
Okay. And when you were speaking with them, that was not consistent with the scene as you had seen it, right?
Again, I don't remember exactly when I got all the information about the shell casings. So at that point, I was getting his statement, and I took it as he gave it to me.
Did you not previously testify about the shell casings? I did not know about it when I interviewed Mitchell and Uten.
Okay, well, if my recollection was that then, I don't remember that now. If I didn't know about the shell casings then, if that's what I said, then that's what I said.
Okay. But you didn't confront them with what at that time would have been their testimony inconsistent with the scene, right?
No.
Okay. And they both told you 1 shooter. The number of shooters they told you was not the same as Miss Smith, correct?
That's the same question, just worded differently.
We've already been through this.
I'm going to overrule that one.
Bernard Mitchell described the shooter coming out of the breezeway, and also the shooter when he was going around. He was right beside he described the person right outside the car shooting in the car.
So that
Described
would be,
dreads and a hoodie.
so that would be he described to you 2 shooters based on what you just told me.
Yes, based on my just reviewing my interview with him the other day.
Okay. All right, I'm gonna have you take, so you don't recall testifying that Mr. Mitchell actually never said anything about two shooters?
I got a sneaking suspicion you're going to show me that I did. But as I sit here, I don't recall that, no.
You were able to review your interview with him, correct?
Yes, I did.
Okay. You still have that transcript in front of you?
No. Oh, is this it?
Yes, sir.
Oh, okay.
You could take a look and see if that helps refresh your recollection about whether he told you there were two shooters.
It may or may not refresh his recollection, but I'm going to object against hearsay with Mr. Mitchell. I'm going to object to hearsay.
This is impeachment of what the officer previously said.
I'll let you ask about whatever he previously said.
Do you have a page or an area that I need to look through? Exactly, it's a long interview.
No, sir.
Quick refresh here of the stream. Sorry about that, folks. The Outcast Podcast here on YouTube. We're going through a witness right now who apparently is not testifying the same as he did in his original testimony. They brought out transcript
I'm
from
going to approach you with what
where
has
he's
already been
testified
previously
before.
admitted into evidence and marked as
Outcast Podcast, YouTube Live, day 150.
Okay.
Okay. And that is one of the CAB reports you've reviewed, correct?
It appears to be a CAD report from the case. I can't say I reviewed it, but this seemed to be from the case, yes.
So you didn't review the CAB, or you did?
Well, I look at it, I verify that it's got the right address on there, and if there's any information as the case progresses, and if I need to get back in touch with anybody, like a 911 caller, I would do that.
Okay. So you didn't see the.
And I would use the CAD report to get that number.
Okay.
And in this particular case, I didn't see the instance to it. Didn't need it.
You didn't need to see the person who wanted to speak with you?
I wasn't aware of that person.
So you didn't review the CAB?
I looked at the front page. I didn't read every word. No, ma'am.
Okay. So you didn't listen to the 911 calls?
No.
Okay. So if you're trying to speak to as many witnesses as you can, why wouldn't you speak to the 911 caller who wants to speak with you?
Again, I didn't get the word that they wanted to speak with me, or I would have. My plate was pretty full. I talked to a lot of people when I did a lot of work that day.
Oh, okay. You were too busy.
Yes, I was busy.
Okay. So when Mr. Mitchell and Mr. Uten, no, let me back up. The photos of the 7.62 shells, you didn't take those, correct?
I did not.
Okay. Were they just sent to you? Is that right?
Yeah, they were included with the report. Yes.
Okay. And so is it from those photos you pieced together, say 10 NN that you've drawn a line on? Thank you. 10 NN, you drew this line, correct?
I did.
Okay. And this earth image or whatever it is, that accurately depicted the apartment complex as you observed it, correct?
That's correct.
Okay. So, and the line on the left side where it starts, that's your belief, that's where the 7.62 shell casings were?
That's correct, yes.
All right. I'm going to put up on the screen for you what has been admitted as 59 NN. I don't know if it needs the share screen. Thank you. All right. So looking at 59 NN, what is it you see next to kind of that entryway, exitway by the sidewalk to the building?
Well, I see satellite dish and an AC unit.
Okay, AC unit. And then you were standing at that AC unit looking at the parking lot. What is to your right? We have a line of bushes.
I'm turned around here. I don't understand what.
If you're standing next to that AC unit with the AC unit on your right, you're looking at the parking lot. Do we have a line of bushes there?
Yes.
All right. Could you flip back to 10 and then? So looking at 10 NN, officer, you said it was consistent. What happened to that line of bushes?
They're not there.
Okay, what happened to the AC unit?
It's not there.
So how is that possible?
Well, when I got the information from the officer, Bob memorialized what he told me, what he found. He said it's by the Y building. I was assuming that Y building was where I indicated right there.
Oh, okay, so
on
you
the
just
map.
assumed that.
I did, yeah.
Okay,
It's in the same complex. The picture with the shell casings is in the same complex. I think it's in the next building back in that.
okay. But so you didn't go out to the scene and see where those 7.62 casings were, right?
I've said that a couple times.
So you can't say for sure actually that 10 NN is even where those were found, right?
That's correct.
Okay,
I can say they came from the complex, but
Fair.
exactly where in the complex, I don't know.
fair. And with this image, I'm going to point you to, that corner right there, right?
Yes.
That's where Ms. Smith indicated one of the shooters would be, correct?
I don't recall that.
Where do you recall she said the shooters were?
She said, if my recollection is correct, she saw somebody walking out of the breezeway.
Here?
Yes. I believe, yes.
Okay. So all those casings should be right there.
Yeah, but the buildings are very similar
Oh.
in design, and there's two sets. So the breezeway, they go through both sets of buildings.
Okay. So they're very similar. So
So it's easily confused is what I'm saying as far as locations, because the buildings look very similar.
okay. So you may have been easily confused, right?
I was confused, yes.
Okay. And Ms. Smith, during the earlier parts of her interview, she had only talked about one shooter, right?
I recall she said she saw someone with a long gun and she heard shots. I don't recall if she indicated whether there's more than one shooter or not. I don't remember that. Should I refer
Okay.
to something?
So earlier on in the interview, or when in her interview, I think you talked about, she said some things which weren't consistent.
Yep.
And then you consoled her,
Yes.
and then she was more consistent after that, right?
Yes.
So when was it that she began telling you, back this up. At what point between those did she go from one shooter to two shooters?
I know when she described to me, she said she described the two guys that she was with, and she described each one of them having a different kind of weapon. I recall that, but I don't recall if she stated that she saw anybody shooting. She stated that she heard shots and ran.
Okay.
Saw both of them with guns, but I don't recall if she said she saw them shooting.
My question was, when in her interview, before or after the consoling?
It was after the consoling.
Okay. Before that, it was only one shooter, right?
I knew that story she was telling me was crap, so I really wasn't paying much attention to it.
Okay.
So I don't remember what
Okay.
she said.
And it was between what was the consoling? We'll go there.
What was what?
When you consoled her,
Mm-hmm.
what do you mean by that?
Well, I'm a husband and a father. Got a daughter. I just spoke to her in a fatherly tone, assured her of her safety, and calmed her down and encouraged her to tell the truth.
Okay. But she didn't start doing that until after she was told to, I think, sing her ass off, right?
I don't recall if that was said or who said it.
You don't recall that.
I'm not saying it wasn't said. I just don't remember who said it. Yeah.
Okay. And there were discussions during that interview about whether she was implicating herself, right?
I don't recall.
Whether she could be going home or not?
I don't remember that.
She wasn't concerned with, or didn't seem as though she was concerned about getting in trouble?
She was concerned about getting in trouble. Yeah.
Okay. And so I want to back it up. She came in, she's telling you a bunch of things, they're not adding up. You console her, and then she is telling you something consistent with the evidence, right?
Yes.
Okay. But that part didn't happen until you were the first one to bring up that someone had a rifle, right? As opposed to just a small gun, right?
I indicated that there were two types of shell casings, a rifle round and a small caliber.
Okay. Before that, she had not described two types of rounds, correct?
Like I said, I haven't seen that interview in quite a while. I do not recall.
Okay. You're the one who brought up a second person there to ambush, right?
I described two types of shell casings indicating that it was two shooters, yes. implication there is it's two shooters.
Okay, so you made that implication and then we had two shooters, right?
Yes.
Okay. What more did you do to confirm what she was telling you?
And what, do you have an example that you'd like me to answer? Because she told me a lot.
Right. She told you about different things that Mr. Mitchell did or Mr. Uten did, right?
Yes.
And those weren't consistent with what you learned from them, right?
Yeah, they were fairly consistent.
Okay. So when you spoke to Mr. Mitchell, that's when you learned about him putting a gun to her head?
Oh, yeah, she did say that about him, yeah.
Yeah.
Again, that's the story I know I didn't believe her, so I
Right.
forgot about it, yeah.
So it would make sense if she's telling you these stories that you would want to confirm them, right?
If it's the truth, yes.
Right. And she told you things about, well, let me ask you. You never went back to Mr. Uten or Mr. Mitchell and asked about whether everyone had been chatting together, like she told you, right?
Oh, no, they described in their interview that they had been texting with the girls.
Oh, I'm sorry. I meant that everyone, the defendants, everyone came out and was chatting together before this happened.
I don't think that came out with Mitchell and,
Okay.
yes.
All right. So they didn't say it, she did, but you didn't go back and say, hey, this witness told me this. No?
No.
Okay. And you didn't go back and look at her Instagram records, right?
I don't think so, no.
So you couldn't confirm whether she said she'd been talking to the victim every day, right?
Bless you, the victim. No, I didn't.
Okay. You could have though, right? Because you said you got a records or you ordered them, did a warrant for them?
Yes.
Okay. And she told you about a specific type of van that Mr. Ryan's mother drove, correct?
Yes.
You didn't go check and see if she actually had a van like that, did you?
Yes.
You did.
Yes.
And that's in your report?
I don't think so, but I did do it. I noticed it. Let me go check. It might be in the report. We went to go talk to his mother.
Mm-hmm. She was cooperative, right?
She was.
You didn't ask to search the van, did you?
No.
That van would have been, based on what you were told, used basically as a getaway vehicle, right?
Yes.
So it could have a murder weapon in it, right?
Yes.
Could have gunshot residue all over the steering wheel, right?
No, unless it was shot from the car.
Okay, those wouldn't transfer from someone's hands?
I don't know, maybe.
Maybe. But you didn't get a search warrant to check either of those things, did you?
No.
And within just a few hours, you had an address for Mr. Blaylock, correct?
I did.
And you didn't get a search warrant for that apartment either.
No.
So you made no effort to look for what would have been the alleged murder weapon, right?
That's correct.
Okay. That would have been useful, right? If you had that, that's great evidence.
I've worked 100 murders. I never got one.
Never.
Ms. Abbasi, let's pause for a minute and take our morning break. And if you, do you want him to look at whatever that
Oh, sure. thank you.
portion was while we break? Okay. All right.
Sure. He's welcome to, and Officer, I'll hand you your other transcripts and you can look at whatever you need to.
All the good stuff happens when I had to step away. I don't know if we're going to break here or what here. If we are going to break, I'm going to rewind back to the mistrial madness that was going on earlier this morning when the state decided that they were not going to recall a witness. Mr. Mitchell here, I think they're talking about on the stand now.
And
They
can I
were-
ask you to actually step outside if you don't mind?
Okay, so it looks like we
Thanks.
got an
I've just
objection
gotta
going on
deal
here.
with another matter.
All right, so let's see what's going on here, folks.
How about you start with whatever it is that you wanted him to actually, that you asked him on the stand about? Okay. I mean, you can give him all of them, but I'd like for him to start with the one that you specifically asked about.
They'll be here.
All right. Okay, so there's been some back and forth about the whole Mitchell, that's his last name, right, thing. And
This is what mistrial was about this morning.
Ms. Abbasi, you said that you kind of gestured in a vague direction towards the holding cell door at the end of the day without mentioning anybody's name, and asked who the witnesses would be tomorrow, which is now today. And the state's answer did not include either of those people. And then, of course, there was some point in time in which the state was maybe going to get Mr. Mitchell, and I don't know what they were going to do, put him on the stand, just, I don't know, as a concession to Ms. Abbasi, maybe. I don't know. Anyway, just FYI, Mr. Mitchell is here and available. I'm just letting y'all know that. And I kind of need to know before the lunch hour, or whenever this
They got him in
next,
here
you know,
now.
the witness that's on the stand right now is over with, if he's going to
The judge finally did
the-
something right.
whatever's going to happen, and then transported away back to where he has been staying before this time.
The issue raised on the defense is his messages would kind of affect what sort of road we went down with the defense. We've already gone down that road.
All right.
The mistrial has been denied. There's no further, I'm no longer insisting at this point he be called. Whatever damage has been done. So working
All
with
right,
what we have.
just wanted to let y'all know. Okay, so then, does the state want to call him? If not, tell me now and I'll have him shipped back.
No, I think this line of hearsay questions has cured any sort of issue as it relates to a mistrial and confronting Mr. Mitchell, since she's been able to do it without Mr. Mitchell even testifying.
All right. Thank you. Let's take our
Okay.
break.
All right, so we're on break time here on the Outcast Podcast, coming to you live here on YouTube. We are going into break. So while the court is in break, I'm going to mute this court here real quick on their live stream. I'm going to jump over here and I'm going to share this tab. This is this morning's mistrial in case you missed it.
Want to huddle? They can
So-
huddle.
And good morning, Your Honor.
Good morning.
The state does intend to call Mr. Lee this morning.
Okay.
He will probably be our third witness this
All
morning. I know Miss Abbasi and I were supposed to speak very briefly after their huddling. We can have just 2 minutes to speak.
Well, I may have them huddle later
Okay.
because the Winnie Lee stuff's more pressing, because you can tender the conviction, in any order.
Yes, Your Honor.
This is a
So,
rewind from this morning's
On the Winnie
mistrial
Lee evidence. is
called
there
by the
any,
defense because Mitchell was
objection
not
that
going to
still
be
needs to
called
be
after all that
hashed out?
evidence came in through testimony
All right.
yesterday. And that
Okay,
yesterday's
and then
testimony
If so, where's the
precipitated
easiest
evidence
place
coming
for me
in
to
that
find
the
the evidence?
defense was
There's something we wanted to address first.
not
Okay.
going to be able to take care of. Okay, here it is right here.
Your Honor, I've got some members of the defense side here taking a look. Our understanding, and if it turns out to be wrong, it turns out to be wrong, was that the state was undecided yesterday as to whether they were going to call Mr. Bernard Mitchell. I know at the lunch break, Mr. Hiles was on the stand. His text messages had already been admitted. We went back to speak with him. The state went back and attempted to speak with him. So at that point, my understanding was it was still up in the air. I can be wrong. My understanding was it was still up in the air. Per Your Honor's request, we had discussed as many things ahead of time as possible. The discussions with the state were, and it was very clear for both sides, that we were not going to be objecting and not asking this court to litigate Mr. Mitchell's Instagram records because the state was going to call him. Yes, with them coming in, there were portions that we intended to use with the understanding that that is what would come out in terms of evidence. His messages would come out, so we would want another section in there. If the first section is in there, we would want the second section in there. But he's certainly not our witness. The evidence he presents is not a theory of the case that we would have brought to the table. And so now the state does not want to call him. And I think we're faced with a confrontation clause issue because we relied in good faith on our discussions with the state. We didn't go through and take the court's time to say this is conditionally admitted based on this happening. So we simply relied on what they represented to us. We had the evidence, came in, it was read out. I contacted the state last night to say, hey, I'm not sure what you want to do about this. We feel in a position that we are forced to ask for a mistrial. We really don't want a mistrial. We'd like to be able to rely on what we were told. And like I said, we're checking to see if there was something definitive on the record.
I'd want a mistrial. I
But if Mr.
really
Mitchell
would.
is not testifying, then we feel we have no option but to ask for a mistrial.
Again, this is
Would the
from this
state like
morning.
to be heard on that?
I guess the state's response, Your Honor, is that the state, after the lunch hour, indicated to
Talking to the mic, pick one up
He
maybe.
cannot pick. He
the
can't talk in
state
the mic.
after the
Man. He's
lunch
got his
hour
glove.
indicated
Sorry.
to the
Next
court,
start's bad about that.
as well as counsel, at least for Mr. Ryan, indicating that we were not going to call Mr. Mitchell, basically because he told not only the state but defense counsel that he wasn't going to say anything when he came onto the stand. That was the same thing that was told to us by Mr. Uten. And my recollection is that it was an either or is what the understanding was. It was we were going to maybe call either Mr. Uten
Maybe
or
call.
Mr. Mitchell.
Maybe.
And yesterday we decided
After all that
neither.
evidence
So I
got
don't know
in.
how there could be a confrontation issue.
Because you
That's
brought in
being claimed
evidence.
today.
You
If
brought in.
we
Okay,
decided
whoa,
to
whoa,
put
whoa, whoa,
Mr.
whoa,
Uten
whoa,
up
whoa, whoa,
yesterday and not Mr.
whoa, whoa,
Mitchell,
whoa, whoa, whoa,
the
whoa, whoa.
records.
You brought in evidence yesterday from Mitchell through another witness, through a police officer. You brought the evidence in already. It's in. And now you are saying, well, I got the evidence in. I don't need this witness anymore. What kind of BS is this? I mean, really, what kind of BS are you serving here, state? Because it is very clear to me, if it ain't clear to anybody else, you got your evidence in. You don't need a witness now because you got your evidence in. Well, now the defense is hung back because they can't question this person now because you're not going to call him because you got in what you needed to get in. Dirty freaking pool. I don't agree with this. I really don't. But again, there's not a whole lot I can do about it. I'm not the judge.
Would have still come in the same fashion without Mr. Mitchell testifying. More importantly, before any message came in as it related to Mr. Mitchell, the state indicated to defense counsel that we were not calling Mr. Mitchell. We indicated that to the court as well.
I don't remember y'all indicating anything to the court until the end of the day, y'all. But what I was told by the deputies was that the state had very clearly said they can be transported back. We are not calling either of them. And that was at or right after the lunch hour that I was told that. I asked yesterday morning, is this an either or? And yesterday morning, the state was definitely indicated, you know, it might be one, it might be the other, it might be both. We don't know yet. We still need to talk with everybody.
And this is the
then
state
we
being
just
slick.
went on with the trial and
And I don't
they didn't-
understand why.
You know, after lunch, they went
Judge,
back
let me-
because
let-
y'all had made that determination and you certainly
Trying to
communicated
build a little
that
bit of a
to
buffer on the other.
the deputies with regard to transport. And you are making the representation that you also let the defense know that. Did y'all disagree that the state let y'all know they didn't intend to call
At
either witness?
Excuse me, at the
Just
very
wanna lay down.
end of the day, I had inquired to the court, said, you know, discuss what's going to be the order tomorrow. And I
Right.
said, well, Mr. Mitchell, Mr. Uten, checking, Mr. Kokomo took a look, and before lunch, what was represented to the court said, you know, who are we going to get to? And they said, we may not get to him today. So
That was before lunch.
that was before lunch, and then we came back in and everything was published.
And everybody I mean, not everybody, but counsel for Mr. Ryan and counsel for the state spoke with, I guess, Uten and Mitchell over the lunch break.
We went back, he didn't want to speak with us, that's fine. We went separately from the state. We
Right.
didn't discuss anything with the state about who would or wouldn't be called at the lunch.
Okay, folks, I'll be right back. My puppy needs to go out. I'm going to stop this right here real quick. Switch y'all back over to the live feed, and I will be back momentarily. This is the Outcast Podcast coming to you live on YouTube. Apologize, folks. I'm back. Outcast Podcast here on YouTube. Oh, Lord, this puppy's going to be the death of me yet. All right. Anyway, let's get back to court is still on break. Let me see. I got a little bit of a buffer here. Let's buffer it out a little bit. Nope, they're still on break. Outcast Podcast here on YouTube. Live YSL day 150. Court is on break. We've had a motion for mistrial already this morning. As usual, the judge found a way to get out of it, so she didn't have to declare it. This has got to be one of the worst judges I've ever seen. I'm actually going to try. I made a new layout, and that is not the layout. That's not the way I had the layout. I had actually. I'm just playing around with a new layout. The court is still on break. So as soon as I get a chance, folks, I'll be right back here. Let me put y'all back on this. Wow, I'm just working on a new layout, folks. Just give me just a minute. All right. Outcast Podcast, live here on YouTube. I am going into this. That's showing y'all the current Love and Outcast Podcast. I'm going to be trying to get a couple of guests in here if I can get the subscribers I need to do it with. But I got a lot of great content that's going to be coming out here soon. I'm working on some stuff now. We're still on break. Let me make sure. Yeah, we're still rolling here. We're not on any type of pause or anything, so we're still waiting on that. But the court is on break. This is the Outcast Podcast coming to you live on YouTube. All right, I see some movement in the court, so we might be fixing to be back here. This is the Outcast Podcast coming to you live on YouTube. Day 150 of the YSL trial. Court is still on break at the moment, folks. We are waiting for them to return from their break. Again, we had that mistrial this morning, motion for mistrial by the defense, based on they thought a witness was going to be coming back. And the state did a slick move and said, no, we got all our evidence in through this witness. We don't need him. And the defense did not object to that evidence based on the representation from the state that that witness would be returning. So the motion for mistrial, of course, was denied by the judge again. And this defense has had to go after this witness with the Mitchell testimony and get in a lot of hearsay because of this other witness not coming in. So we're just waiting on them to come back in here. This is the YSL trial, day 150 here on YouTube, Outcast Podcast. And if you make it this far, or if you come into this time, please subscribe, help me grow the channel. I've got a lot more stuff coming. I'm working on now. The YSL trial is just so I can get used to the software that I'm using, so that when I get ready to actually do the in-depth podcast that I'm going to be doing, I'll know how to operate the equipment properly to do it. But this is going to be a few more days of me doing this, and then I'm going to switch over to my other content because there's so many creators out there right now, fellow YouTubers that are doing the YSL trial, that I'm basically up against some people who've been doing it from day one and have gotten their following. And I know I'm not going to get a following like that. So I'm going to be going after some different content and trying some different things. But this is the YSL trial day 150. Like I said, I'll have 1 or 2 more days that I'll be doing this. And then I'm going to switch over to different content so that I can try to grow my following based on a different type of content. This is one of the longer breaks, so either they're trying to work something out during this break, or the judge is taking a little bit longer. She might be trying to review something. And I wouldn't put it past Brian Steele, Max Shart, Mr. Adams, Mr. Williams, Misty Williams, to fashion a big mistrial motion based on what happened this morning, and maybe cultivate some other things. And I think I seen the witness just coming back in. We may be getting ready to rock and roll here. Okay, the volume is up. So we're just waiting on them to come in now. YSL Day 150. What are your thoughts on this trial? Leave them in the comments, or you can email me at outcastpodcastsc@gmail.com, and I'll look at your email, and we'll go from there. I'll either email you back or we'll put it into a video. One of the two. But I do interact with anybody who sends me an email. you will get an answer one of two ways. You will either get a email back, or I will happily uh, bring it up on one of my podcasts. Here on the Outcast podcast. Here we go, folks. We're back. They haven't brought the volume back up yet. Let's make sure it's up on my side. All right, let me refresh it real quick. Let me stop sharing and reshare, and let's see if that happens to bring it back. All right, well, let me refresh the stream. Maybe Law and Order is just falling way behind here, because I'm not hearing any volume. All right, well, let's see what's going on.
What were the warrants you took out for Mr. Ryan?
All right, we're back. YSL Day 150.
The only person who ever gave you any indication that Mr. Ryan knew Mitchell, Mr. Uten, the victim, anyone in the car was Mariah. She's the only person who said they knew one another, right?
That, you confused me a little bit. Say that again. Say it again.
The only person who said that Mr. Ryan knew Mr. Uten, the victim, Mr. Holmes, Mr. Mitchell, only person who said they knew each other was Mariah, correct?
I don't recall that.
Did you look at your interview?
Well, I'll be honest with you, I did, but I forgot what you asked me for to be looking for in there.
Okay.
Maybe it's a question. Ask me each person at a time. So Mariah, you're saying Mariah said she knew Mitchell.
Mariah told you was the only Mariah indicated, whether through this or something else, Mr. Ryan had some contact, knew the existence of Mr. Uten, Mr. Mitchell, Mr. Holmes, right? You never went to any of them and said, hey, do you know this guy?
No.
Okay. And they never, gave you any names saying, I think it was this person, or I have a problem with this, nothing.
They who?
Mr. Mitchell and Mr. Uten.
They said they did not know who shot at them.
Had no idea.
That's correct.
And didn't ask them if they, had any problems with Mr. Ryan or Mr. Blaylock, right?
Yeah, they're correct. Yeah.
Okay. And Mariah, she never told you anything about being locked in a basement, did she?
I don't recall that, no.
Okay. And she didn't tell you anything about Mr. Blaylock attacking her, did she?
Other than when Mr. Blaylock. Oh, no.
Okay.
No, not that I remember.
All right. And so based on the evidence you had, the person who fired the 7.62 was tall, right?
I was described, he was described as being tall, I believe.
All
Just
right.
a second, let me double check it. Just a second.
And I can get you a transcript of your interview with Mr. Uten if that further helps.
I bet you can. Let me see. Yes,
Okay. So Mr. 762 is tall. And based on all of that evidence, was your conclusion that Mr. Blaylock was the one with the 762, right? Page
go-
18?
Page 18. Of what? Which one am I looking at?
Your report.
Well, if you got a page 18, you're doing better than me. I got 17 pages.
Oh.
Okay, wow. You got more than me. Okay, I see what you're referring to, yes.
Yep. So final conclusion you came to based on everything you reviewed was that Mr. Blaylock had the rifle.
That's what I wrote, yes.
Gotcha. All right. So we have rifle rounds, and then we have all these other casings from a smaller gun, from a 9mm, correct?
Yes,
All right. And those casings were found very, very close to the vehicle where the victim was, correct?
there were casings on top of the car, yes.
Okay. And casings on top of the car, you don't know how they got there, did you? Or do you?
I didn't see them be placed there or fall there, no.
Okay. Did you speak to the EMS, the emergency services people who
They-
would have been there
They
responding?
they were gone when I got there.
Okay. So you're not sure whether they had to move anything to get to Mr. Holmes?
It was obvious that the hat we found on top of the car was placed there by someone.
Right.
I don't know who. But I guess it's plausible that somebody would say, hey, there's a shell casing, let's put it on top of the car.
Yeah. So they
Don't know-
wouldn't want to lose it.
Don't know why they do that, but yeah.
Okay. So you discussed with Mr. Mitchell and Mr. Uten whether they had guns, correct?
Yes,
They both had guns, right?
yes.
And you never asked them if they shot, did you?
Mitchell said his gun was empty.
Okay.
Uten, I don't recall ever asking that specific question.
Right. You didn't ask him what kind of a gun he had, right?
I don't recall
Okay.
asking him.
You asked him what happened to it though later, right?
Yes.
And he indicated to you that you should.
All of this is hearsay. What whoever indicated to whoever.
Sustained.
Okay. Did you have an occasion to either you yourself or have somebody go looking in the woods for a firearm?
Wasn't me, but yes.
Okay. And beyond that, you did not have any follow-up to tracking down those guns, right?
That's correct.
All right. And your reason for that, you previously testified, was you had no reason to, right?
I had no further leads. Once we tried to find them and couldn't, based on where they said they put them,
Okay.
there was nowhere else to go.
So you had no reason to try and find out whether Mr. Putin was the one who fired all those 9mm.
Say that again?
So you had no reason to try and figure out if Mr. Uten is the person who fired all those 9mm.
Right, I didn't try.
Because if he did, that would be your second shooter, right?
Your Honor, objection calls for speculation.
Sustained.
You at some point had an occasion to review Mr. Mitchell's Instagram records, correct?
Again, I'm not a computer guy.
Far later.
I allow other people on the team examine those. I trust them in what they can do because they're
Mm-hmm.
a teenager's better than me on that stuff.
Yep.
So I looked at the report or what was given to me. Did not do a deep dive, no ma'am.
No. No deep dive. You didn't look at them.
Say it again?
No deep dive. I mean, you did not look at them, right?
I don't recall if I did, yeah.
Okay. So you never did any follow-up with Mr. Mitchell about him shooting back, did you?
No.
But you
Okay, she's got a very good line of questioning here. She's questioning whether or not he seen if either one of these other two guys shot, if they could have been the second shooter. So it could have been one shooter and one of them. And no follow up was done with this. This is crappy police work, and she's doing a great job bringing it out. Great job there.
learned that at some point he said he did, right? Or they did.
Yes, I did hear that, yes.
Thank you, Detective.
Oh, you're welcome. You didn't get this stuff back?
Are there
That's all yours. You're welcome.
other defense counsel with questions for this witness?
Good morning, Detective Hogan.
Did check the time. Good morning. Good morning.
Um, We've met before, but my name's Max Shard. I represent Shannon Stillwell, okay?
Okay.
All right, and the case that we're talking today does not involve Shannon Stillwell at all, does it?
Not that I know of, no.
Okay. I just wanted to ask you one question on cross. You were asked about testing a car, the inside of a car for gunshot residue.
Right, yeah. I remember.
And you responded that it would not make any sense to do so unless a gun was shot from that car, correct?
That would be the most obvious reason to do so, yes.
Most
Okay,
obvious
so
reason.
if a gun
Not
is
good
shot
police
from
work, but,
inside
hey,
a
you know.
car, if your investigation leads you to believe that a gun was shot from inside a car, you certainly would test for gunshot
Yeah,
residue,
he would.
correct?
For
If
that,
there was any question that a gun was used
is
inside the
crappy
car, so
police
if
work.
there's an allegation that there was,
Crappy.
and
Yep.
then there was reason to believe that it wasn't, we needed to prove that a gun was used in the car, then certainly we should process the inside of the car for gunshot residue.
Okay, when you say process inside the car for gunshot residue, what does that mean?
Well, we asked the ID unit. I've watched them do it several times. They have a Q-tip, and they swab areas, and they preserve that Q-tip, which gets sent to the GBI crime lab. And then they do their analysis, their whiz bank stuff over there to say if there's any presence of gunpowder, I guess is what it is.
And we're talking about microscopic particles,
Yeah,
right?
if you shoot a weapon anywhere, if somebody shot in here, the residue would be however tiny, microscopic, but it would be here on everybody, everywhere. Yeah,
It would go all over.
yeah, it goes everywhere.
Okay, and you would ask the collection team, we'll say, to the crime scene technicians, I guess is the formal term, correct?
Yes,
You would ask them to collect from the different areas within the car.
that's
What
correct.
are there any specific areas that you would have them focus on?
Generally let them do their job. They know more about that stuff than me. I ask them to process it and I allow them to do it.
Okay.
So wherever areas they are. Another's, the GBI has been a little more stringent on their testing of that. They're getting away from gunshot residue because of the fact it goes everywhere. It doesn't really prove anything.
Okay, so the concern when they're going away from it is not that it gives false negatives, but it gives false positives.
Right. So for example, if you're a gunshot victim, you're obviously a gunshot victim. Guys that in the past I know have tried to test them for gunshot residue. Well, that's kind of silly because they are a gunshot victim. They're going to have gunshot residue on them. Also, the fact that if they're in a room such as this or other people, and somebody shoots and then that person gets away, but somebody else is alleged to be the shooter. Well, if he was in the same room, he's going to have gunshot residue on him as well because it goes everywhere.
So it sounds like what you're saying, if you get a positive result from gunshot residue, it may be unreliable for proving what you're intending it to prove.
You don't necessarily have to be the shooter if you were in the room when the shot went off.
But if you get it, but from what I'm understanding, if you get a negative, that's still a reliable result. It's just the positives can mean different things.
Yes.
All right, great. And in your experience at times, you said you defer to the experts on the collection method. Have you known them to remove different parts of a car for further testing for gunshot residue?
Yes. Oh.
Sustained.
I can approach it. It is going to be relevant.
All right, I'll give you.
And I'm
some.
just going to ask one more question. Is
Okay.
one of those parts that the experts remove at times the headliner of the car?
Yes.
Okay. Thank you. No further questions.
You're welcome.
Any other defense? Go ahead.
Mr. Bossy did the
Good morning.
best there.
Good morning.
Here's Brian Steele. It's going to be
How
quick
are
with
you?
him. I
I'm great.
promise you it'll be quick with him.
I'd like to ask you, in your work, have you ever had the need or the opportunity to ask for and secure surveillance cameras from businesses?
Several occasions, yes.
Okay. Can you tell the ladies and gentlemen jury, in your experience, have you ever had a surveillance camera operation where it would be a specific period of time that was captured? The images were captured by the surveillance camera.
Sure. Every system's different. There are some, from my experience, some common denominators. Most surveillance systems capture a certain period of time. That's generally around 2 weeks.
We may go to lunch
But
before
after those
we
2 weeks time
move on
period
to another
stops,
witness. I don't know what the state's going to do here and how
gotta
long the
imagine
state's
that
going to be.
you're
Coming up on
shoving
12
video
o'clock.
into a tube.
So that's what the
As it
judge
comes
does
out,
here.
There's so much space to capture and to maintain. So as you
I
capture
just
more
feel another
video, it
mistrial
starts
being
falling off on the
motion
backside
coming
of
up here
2
for some
weeks.
reason.
So for example, if 3 weeks ago there was a crime that we became aware of and we needed to try to get the video, we call if it's past that 2 week time period, the video is no longer accessible. It's been deleted. It's been overwritten and it's gone.
So in your example about the 3 weeks, so a video can hold up to 2 weeks of information, is what you're telling the jurors in our example.
It's kind of a general rule, Brian. But there are systems that capture and they keep them for longer periods of time, but those are expensive to maintain, and that's pretty rare that we have, but they're out there.
So if, just hypothetically, if we start on day 1 and the surveillance equipment can hold 2 weeks, so on day 14, from day 1 to day 14, it's all there if it's all working correctly. That's what I hear you say.
Yes.
I'm going to object to relevance.
It goes back. Now, on day 15, so day 14 ends, now it's day 15. Are you telling the jury that in your experience, day 1 is now gone, so now we'd have from day 2 to day 15?
That's my experience, yes.
Okay. Have you ever, tell the ladies and gentlemen jury, on day 15, so day 15 starts, all day 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 are gone?
Without a catastrophic failure of the system, I have never heard of that. No.
Thank you. Thank you, Your Honor.
Anybody else? No question. All right, redirect.
Detective Hogan, do you recall Ms. Abbasi asking you about your interview with Ms. Smith and how she, I guess, about how she described the long gun? Remember her asking you about that?
Yes,
Do you remember her specifically asking you about the use of the term rifle?
yes.
And do you recall, based on your interview, Miss uh, Smith was only able to describe the gun as a long gun, correct?
Yeah, she was not um, well versed in.
You can answer the
She
question.
was not well versed in guns. She was using pretty generic terms. Yes.
Now, I want to bring your attention to something that Ms. Abbasi just, one of her last questions, she talked to you about how Ms. Smith just kind of described or said how Mr. Ryan or somebody would know any other parties. Remember her asking you about that?
Yes.
And do you remember what Miss Smith's response was, or conversation with you was about how Mr. Ryan would or knew Mr. Mitchell?
Your Honor, I'm going to object to this. It's
Right.
not the question. The question was whether anyone besides Ms. Smith described them knowing one another.
I think she opened the door as to how.
Go ahead.
Do you recall?
Of how Miss Smith knew Mr. Mitchell?
No, about how the question that Miss Abbasi asked you was about how Miss Smith described to you and talked to you about how Mr. Ryan knew Mr. Mitchell. Do you remember her having that conversation with you? And if looking at a copy of the transcript would help refresh your recollection of your interview with Miss Smith.
Sure, man.
I want to direct your attention to page 93, where the minute marker is 2:18:21.
And Your Honor, I'm going to object to this being hearsay. We're not impeaching her.
What are you gonna ask?
What she said. I mean, counsel opened the doors when she asked the question as it related to the conversation that the detective had with Miss Smith about how the parties knew each other.
So are you refreshing his recollection as to what you said
That's-
about it?
That's correct, Judge.
I'm gonna permit it.
Your Honor, the question was about whether anyone else described them knowing one another, not what she said, how.
All right, I'm gonna allow it.
I can ask the question again, Detective, after you've reviewed.
Yeah, you're gonna have to. Give me a second. Okay, I'm with you.
Okay, so in reviewing page 93 of the transcript of the interview with Ms. Smith, can you tell the jurors, is your recollection refreshed as to what Ms. Smith indicated or told you about how Lil Rod or Rod and Mr. Mitchell were familiar or knew each other?
Yes.
And can you tell the jurors, what did she tell you?
She said that little Rod told her that BJ took his gun, Mitchell took his gun.
Now, I also want to talk to you about a question that Ms. Abbasi asked you as it related to describing, as you spoke with Ms. Smith, that this was an ambush. Do you remember her asking you about that, using the term ambush?
I remember using that term. Can you tell me where to look? I don't recall it in the interview.
No, what I'm asking you is during your cross-examination, Ms. Abbasi had asked you some questions as it related to you describing or using the term ambush. Do you remember that?
Yes.
And can you tell the jurors or describe to the jurors why your investigation and through your investigation, tell the jurors why you called it an ambush?
It wasn't a robbery. Shooters never approached the vehicle. They were lured to a certain spot.
Your Honor, I'm going to object with him testifying as these are actual facts. He can say what he investigated, what he did or did not.
Sustained.
So I'll rephrase the question. Can you tell the jurors what in your investigation drew you to characterize or classify this shooting as an ambush?
It wasn't telegraphed. It was sudden. They snuck up from behind and
I'm going to object again.
Sustained.
Same thing.
I'll move on. I want to put up State's Exhibit 10NN. Well, before I move on, and as she's putting up the photograph, based on you said that you were in homicide for how many years?
10 years.
And you said you've worked in law enforcement since you said 1987.
Yes.
How many years is that?
A lot. 36, 37.
Okay. And can you tell the jurors, based on your training and your number of years of experience, well, let me ask you this. Before you worked in homicide, did you work cases that also involved shootings, but no deaths?
Yes.
And can you tell the jurors, based on your number of years of experience and your number of cases that you've worked that involve shootings, what the term ambush means in relation to your investigations?
Something that's sudden, unexpected, where the victim in that situation is pinched in or in a small area that he's hard to get out of or he can't get out of. Sit and duck kind of a thing.
Okay. Now, you see the photograph in State's Exhibit 10NN.
Yes.
Can you tell the jurors, is that drawn to scale?
No.
And can you tell the jurors, did you intend that photograph to, or that drawing to be an exact replica of the scene?
No.
What was the purpose of using State's Exhibit or drawing State's Exhibit 10NN?
It was just a way to kind of demonstrate what my theory was at the time when I created it.
And in your drawing, can you, well, I want to take you to State's Exhibit 18NN. Now, in State's Exhibit 18NN, can you tell the jurors in this photo and you're actually being at the scene, can you tell the jurors how many breezeways are in the building that we're looking in front of right there?
Just one.
Okay. And in your drawing, how many breezeways were depicted in your not to scale drawing?
One.
Okay. And I want to show you State's Exhibit, I think it's 17NN. Yes. So do you see 17NN?
Yes.
Can you point to the jurors in this different angle of the building, where on this exhibit would the breezeway be? Would it be on the left-hand side, the right-hand side?
The sidewalk leads to It's off camera right here.
Okay, and then you see where on the right-hand side it states that it's 17th and the building kind of intersects or meets with another building. You see that?
This here?
Yes.
Yes.
And I want to show you States Exhibit 59NN. Now, in this exhibit's 59NN, can you show the jurors where in that exhibit are the shell casings that you described previously that were found in that area of the crime scene?
They're indicated with the yellow placards.
Okay. And in comparison to or in relation to your not to scale drawing in States Exhibit 10NN, did you place red dots on that photograph to depict something similar?
Yes.
Okay. And when you were putting the red dots on States Exhibit 10NN, did you put exactly 15 or what were the dots there to represent?
They were there to represent the shell casings.
And were they there to represent the shell casings, the general area where they were found?
That's correct.
And was in reviewing your drawing, States Exhibit 10NN, is where you generally put the red dots consistent with where we saw the actual shell casings found on the crime scene?
When I created the drawing, that's where I thought they were, yes.
And while on scene, let me ask you this question. How long was law enforcement generally, if you know, on scene that night or that early morning at the scene of the shooting?
3 to 4 hours, maybe a little longer, I guess.
And in the time that you were there, did anyone approach you who had called 911 to speak?
No.
Now, Ms. Abbasi asked you some questions as it relates to how many shooters Ms. Ms. Smith described. You remember that?
Yes.
Can you tell the jurors, after the initial part of your interview that you described earlier with Ms. Smith, did she consistently, after you confronted her with the physical evidence, describe the fact that there were always two shooters?
Yes.
And can you tell the jurors during that interview, was it you or was it her who placed nicknames in relations to those two shooters?
It was her.
And before Miss Smith told you that, did you have any idea of the nicknames of who she said the two shooters were?
I did not.
And do you remember during that interview, Miss Smith describing Mr. Uten and Mr. Mitchell running from the blue Charger?
Yes.
And can you tell the jurors at any point during her interview, did she describe to you that as they were running?
Your Honor, I'm going to object to this as leading.
Sustained.
I'll withdraw the question. But I do want to ask you, Ms. Abbasi asked you about, let me ask you this question. Through your number of years as a law enforcement officer, have you received a number of trainings as it relates to firearms?
Yes.
And through your work with the Atlanta Police Department and the other law enforcement agencies, you worked with before that. Can you tell the jurors, are you familiar with a revolver?
Yes.
Okay. Can you tell the jurors how is a revolver different from, let's say, a 9mm handgun or pistol?
Namely, there's several big differences between a 9mm semi-automatic handgun and a revolver. Revolver is self-contained. It has a cylinder. It's in the middle of the gun. When you, it's either double or single action. If it's a double action, when you pull the trigger, it rotates the cylinder and at the same time pulls the hammer back. When the hammer falls as the next shell casing comes up into the barrel. It hits the firing pin and it shoots the projectile out of the front of the weapon. Biggest difference there is there's no shell casings that come out. The operator can open the weapon and dump the shell casings out, but it doesn't automatically eject them. Semi-automatic, 9mm. When you pull the trigger, it's a very similar action, except there's no cylinder. There's a spring that when you pull the slide back, a shell or a projectile with a shell is lifted slightly up from the clip. There's a clip that catches the projectile and puts it in the barrel ready to shoot. And then when you pull the trigger, a firing pin goes forward, projectile goes out the front. The slide automatically from gas pressure gets pushed backwards. The next shell casing is lifted up by a spring. It ejects the shell casing out, usually to the right, and then it goes forward, picks up the next projectile and shell casing to go into the barrel, ready to shoot again.
Okay. Now, in the vehicle, the blue Charger, can you tell the jurors were the defects that you observed in the car in the front or in the back of the vehicle?
Back and side.
Okay. And were there any, I guess, defects in the front of the vehicle?
Don't think so, no, sir.
And is the defects being found in the back of the vehicle consistent with the vehicle being backed in or parked with the back end closest to the breezeway and the front end kind of closest to the access road?
Your Honor, I reject this as speculation.
Well, he said consistent with, overruled.
The damage that I saw was consistent with it being attacked from the rear and from the driver's side.
One moment, Your Honor. No, I'm further at this time.
Be very quick, Your Honor.
Go ahead.
Detective, when you were speaking with Mr. Mitchell and Mr. Uten, you were trying to figure out if they had any idea why the shooting would have occurred, correct?
Yes.
And you addressed with them whether either of them had stolen anything, right?
Overruled.
I did.
Okay. And you had no indication that that would have been the reason here, right?
I tried to figure out with Mr. Mitchell, especially of the motive for what happened. Wasn't successful in speaking to him about that.
And Ms. Smith's statement about Mr. Ryan having stolen a gun, what did you do to vet that statement?
Mr. Mitchell stole a gun.
I'm sorry. My apologies. What did you do to vet that statement?
Nothing.
You said no?
I didn't vet it.
Okay.
I just took it.
Mr. Abate asked you about whether after Ms. Smith began talking about two shooters, whether she remained consistent about that. And you had no reason to press her and suggest otherwise, right? Because that was your theory, right?
That's correct, yes.
Thank you.
All right. Thank you for your time. Well, I guess I shouldn't have assumed that no other defense attorneys had recross. All right. I just happened to be correct. Okay. All right. Thank you for your time. You're excused.
Thank you, Judge.
And this seems like a good time to break for lunch. So we will break for lunch until, I think we've probably got some work to do during lunch. So I'm going to give the jurors until 1:30.
All right, y'all. We're back with Outcast Podcast here on YouTube Live, continuing coverage day 150 of the YSL trial. The court is going to lunch. They're sending the jurors to lunch till 1:30. The court has some other work to do. As y'all may or may not know, this morning there was a motion for mistrial based on a witness not being brought after testimony was given yesterday and evidence was presented that Mr. Mitchell was supposed to come in and be examined by the defense and the state, and then the state decided not to call them. So the motion for mistrial was made this morning by the defense. Continuing coverage right here on YouTube of the YSL trial day 150. Let's see what the court's going to do now. If they're going to go to lunch first and then come in and work on the issues, which would make sense, or if they're going to try to deal with the issues first and then go to lunch. Let's see what our taste is
All right.
today.
We need to deal with the Wooney evidence.
Ooh.
How long do you think that's going to take?
It should only take about 15.
All right. Why don't we just do that before we break then?
All right, we're going to go right into it. How much y'all want to bet? It takes more than 15 minutes. It is currently 12:06. 15 minutes would be like what? 12:20. Well, let's see. 20 minutes would be 12:26. Let's say 12:30. I doubt they get done by 12:30. They might be, but I doubt it. But let's see what's going to happen here. Is the state going to go first, or is this going to be a defense? Ms. Abbasi. Let's say she's going to start things off here.
And I'm sorry, did y'all get to the point of forwarding
Yes.
the document
Did I forward it to you, Ms. Percival? Yes.
this morning? Yep, there it is. Okay. All right, so I've got that open. So if you can start directing me to which items are at issue. This is in, okay, Instagram. Is that right?
Yes, sure. And I'll say most of the items in this packet will probably only come in if I have to impeach Mr. Lee. So we can definitely go through it, but just to set the stage, Your Honor, about what the items in here are.
Okay, so is everything that's in here we need to litigate? Is that what it is?
Yes.
Okay.
I'll begin pages 1 and 2. So let's start with 1. Page 1 appears to be a conversation. Mr. Lee is the slimelife.shoddy. This is a conversation where he says, get somebody to buy my Switch. The next page is a photo of a firearm. I'm not sure how that suggests any sort of illegal activity whatsoever.
Your Honor, the fact that he has access to a switch in and of itself is illegal to have a switch for a firearm, Your Honor.
Have y'all charged him with that?
No, Your Honor. And for the first page, he has not been charged with a switch. And so we won't enter in page 1. Page 2 or page 3, Your Honor, which is Mr. Lee with a firearm, Your Honor.
Are
Again,
you talking about the hand?
the hand, yes,
Can you establish that that's him?
it's his Instagram
Ooh.
record, Your Honor, and it's something that I would
Ooh.
ask.
Ooh.
No. If that's the
Ooh.
best you can do, that's just a picture of somebody.
Fine, Judge.
Permitted. Unless you ask him, is that your hand? And he says yes.
And that's why I started trying that most of this is for impeachment, because it would depend on the questions that I ask of him, whether or not this becomes relevant. So that's why I
Well,
started.
I mean, I guess you
with
can
it.
present him with it if he said, if you for some reason are able to ask him, did he ever have a switch? And he says no, you can, without showing the jury, present this. And if he says, oh yeah, that's me, then we've got one thing, but okay. Moving
Hmm.
on to the next item.
Page 3, Your Honor, I don't know how Mr. Lee is involved in this. I don't see his screen name on here, so.
I'm not sure which page you're calling, page 3. Page
Well,
3 I
the
have is
third
doc-
page of this document,
I'm
which
sorry.
is
page
page
4.
17 and/or page 2313.
Yeah, we're withdrawing this page.
Okay.
Page 2314 is a photo of, this time it's a leg with a gun.
Your Honor, it would be the
Mhm.
same position as the
All
first
right.
one.
Next.
The next one, page 5, which is the top Instagram page number 24836. The majority of this conversation is from author FOEVAKT. That would be hearsay. I'm not sure under what theory it would be admissible. It seems to be talking about business and a song.
Your Honor, we're going to withdraw this one.
All right.
You notice how they withdraw something that they try to sneak in and they get called for it? Total BS. Well, Whitaker,
What
why
about
are you
page
putting up with
6?
this?
I would defer to other attorneys if they have any objection to page 6.
Does anybody have an objection to page 6? Oh, I hear Brian Steele.
Your Honor, I object unless there's a better, or some foundation. I heard what the prosecutor said, that they would not
Attempt to use it unless they lay a foundation or impeachment, but I don't know who these speakers are, except I assume that slimelife.shawty, SHAWTY, is the witness. But other than that,
Right.
I would object. I don't know if it falls under any type of hearsay exception.
The first post on June 4th of 2019, the witness who's testifying says the YFN expletives are at your house.
Mhm.
And then a couple lines later, he says, just stay out of their way, bro. Too much going on. I'll come light that bitch up if they play with you. So considering that we put testimony in about
Ooh.
the mother of Mr. Bennett's home, who is a member of that same YFN group that was shot twice. We've been discussing this back and forth quite extensively. So the fact that he's talking about explicitly stating the YFN group and he's going to come light it up in reference to shooting either at or towards those people, I think it's quite relevant to stand. So any questions or explanation he wants to give for that, he most certainly can.
So what about the other part of the conversation?
Yeah, what about it? Come on.
Are you not offering that part? Gonna redact that part?
Are you going to redact it?
So, Your Honor,
Nope, he's going
This
to come
is
up
a
with a
back and
BS
forth
reason.
conversation that he has with
Yep, here he comes.
this other individual. And so
Here's
I
the
don't
other
know what
individual.
specifically, I mean, the bottom three, I don't know what specific line that defense is stating is not needed for the context of what Mr. Lee stated here.
Well, certainly the last
The last,
bit of it isn't needed, but I mean, I don't, not since all that X has been going on, been happening. We don't know who this is, and that
We
is
don't. We
indicative
do
of
not know who
stuff's
it
been
is.
going down.
Yes, Your Honor. And the state,
They
what I
want to
just
get it
read,
in,
what's
and they have
highlighted is
no
what the
idea
state,
who
that's
is
why we
saying.
included
Okay,
this.
and I'm
so
asking if you're going to redact
Hmm.
it, because if you throw that up on the screen, anybody, I know that the highlighted part is what you're highlighting, but the rest of it is easily visible.
Yes,
So
Your
are you
Honor.
going to redact?
We can redact it and keep that just the username so it doesn't appear that he's just speaking to himself.
Okay.
And we will take out where he says everything else he says. That's perfectly fine, Your Honor.
All right. Page 7.
Yes, Your Honor, page 7, this is going to be a combination. We have a hearsay within hearsay. We have Mr. Lee asking who Fat was talking to. I'm not sure the relevance because I don't know who Fat is. They might ask questions which make it relevant, different conversation. But the response from someone who's not testifying is what that person heard. So we have hearsay within hearsay. The next statement is also from this other person who I'm not familiar with who the speaker is. Mr. Lee's response is ambivalent, just say no more. And there's not any further conversation that I see would be relevant.
What's the state's response?
Well, Your Honor, we need this because we have no case, so we
Specific
need this.
exchange, it's very predicated on what Mr. Lee responds. His response is on the stand. If he says, just like the post I just referenced before, if he says, I've never heard of YFN, I have no problems with them, I'm actually quite friendly with them, they're not opposition to me, I hang out with them weekly, then these kind of threads could become relevant, where they're saying, I just heard he was with Slime. he told me
Could
he was
become
with
relevant.
YFN,"
Again,
and then the
could.
person, again,
They're
not,
just trying to throw anything and everything
Mr.
they
Lee
can in
testifying
this
says
case.
that those people are
Half
ops,
this
and then he
crap doesn't even
responds,
make
"Say no
sense.
more." That in conjunction with like the one we just spoke about, I don't know the exact question we would ask Mr. Lee, but none of these conversations, if an improper question is asked and the court sustains the objection, you will never have the predicate foundation to introduce this. And so I do think it hinges very much on how his testimony.
I think that
Yes, Your
before
Honor.
you think it's appropriate to use this, y'all need to approach, because I am having a hard time envisioning how
Yes, Your
this
Honor.
would be appropriately used.
Yes, Your Honor.
Okay.
Mm-hmm.
Next page, Your Honor, is
About time.
page
Keep it going,
8,
Paige.
and a conversation
good.
between Slack
Knocking them down
and
some.
Mr. Lee. Again, I think we have hearsay. We don't know who Slack Quay is or what his possible involvement could be. They're talking, it sounds like, about something which happened in the past.
Mm-hmm.
I'm not sure how that would come in as any hearsay. It
Mm-hmm.
would be, if anything, spilling the beans, not furthering the interests of the gang. If that's even the exception they're trying to use, I don't know.
You're right. I think that falls in the
All right,
same
now,
line of
fine.
argument that this conversation would fall into that same line of what Mr. Atkins just articulated. Your Honor. Page 29, Your Honor, would be, I think, in line with the same articulation that Mr. Atkins just did for the page before. It's the same individual. It's the same conversation. The same
So
two people in
It
conversation.
would be to potentially establish that, yes, he did know who YFN were, and that was significant to him in some way.
Yes, Your Honor.
That's potentially a better example of it than the one above. Talk into your mic. Talk into your mic and talk to me.
Was talking to you, Your Honor.
Okay, because you're gesturing over at them.
I know, but I believe this is what I referred to the other day with regard to the person that is identified as Slat Qua, not Quay, but it's Slat Qua. One has not been identified, but it is certainly no one in this courtroom, and I believe that the state will elicit that. This is my understanding, and I'm looking at you, Judge. It's my understanding that that would be the testimony. If there's anything else, I want an opportunity to.
It was my understanding that the state and the defense were going to enter into a stipulation that any reference to a qua here or wherever it comes in this Instagram, there was a stipulation that it wasn't any of the people nicknamed Qua or Quay in this courtroom. Have y'all not done that?
Judge, that's been my understanding as well.
We're-
However,
We're still working on that.
All right, well, sounds like we might need to get to it before Wooney Lee testifies.
I agree.
Your Honor, myself and Mr. Harvey had spoken a short while ago where asking this witness, this is his thread of who is this? And then I do not know what his response will be at this moment, but I do not expect him to say it is Mr. Nichols or Mr. Huey. And whoever he says, if he says, I don't know who that is, you can ask him, is there anyone in this courtroom here today? And if he says no, I think it will be crystal clear that that was what me and Harvey were, we hadn't finalized it, but that was what we were discussing. The state's not trying to insinuate.
Discuss
it's
it with
anyone in the
Mr.
courtroom.
Matthews also.
Yes, yes, Your Honor.
If y'all come to an agreement, that's fine.
Your Honor, I will.
And why don't you let me know what that agreement is before Mr. Lee testifies?
Your Honor, Mr. Rubin, Mr. Lee's attorney is here. I will ask Mr. Rubin and we'll have that answer before lunch, by the
Okay.
time we come back from lunch.
And Your
Going
Honor,
to ask the attorney what the answer to that question is.
So he
gonna
can
be?
ask his client, that's Mr. Lee's attorney, so we can get the answer of who Slack Quay is over the
Okay,
break.
and then what if he says one thing to his attorney now and then he says another thing on the stand? Are we going to have another specter of putting an attorney on the stand?
No, Your Honor,
Not-
I believe that we have been in communication with each other. So I don't think that result
I'm not
will
sure
occur.
that that's going to resolve it, but if the state and Mr. Matthews and Mr. Harvey come to an agreement about that, that's fine. Y'all let me know.
We will.
Okay, next.
Your Honor,
So is there another objection besides we need to make sure that everybody knows who this is or isn't the Slack Qua?
I do, unless it's
Okay.
coming in under 248807 D2E. All that Mr. Lee, according to this.
All right, remember I
document,
said 12:30, folks.
All he
It's
says is you
12:22.
all got into it with
We're
them.
gonna be about 15
Everything else
minutes.
would come from this
Start
other
at
person, so that's
12:06.
my objection as well. That page really is not very illuminating on what Mr. Lee is doing to further the interests of the alleged conspiracy.
So it would be, as I understand the state's position, it would come in to impeach Mr. Lee if he claims not to know who YFN is. Is that correct?
Yes,
Oh my God.
Okay. And so do you the entirety of it?
They want everything they can get what they need or not, Judge. You know that.
This is.
Why don't
I'm-
y'all just
I
let
mean, I'm
them bring
looking
in
at
whatever they want to bring
page.
in? Let the defense bring in whatever they want to bring in and just let the chips fall where they may.
1397.
Because y'all already letting so
The
much illegal
highlighted
stuff
portions
in.
of
It wouldn't make a
1397.
freaking difference right now anyway.
To the court on page 854, which I think is 2 pages forward or above. It's Mr. Lee. It's identified as Mr. Lee's Instagram account, and it says YFN ends be by your house. So I don't see why we would need it on another page.
A different one. Oh, that's true. Okay, so.
The state's position remains the same. This will become relevant depending upon the question. So this might not come in at all. And so what would the court like for us to answer.
So if there is already something in, Mr. Steele makes the point that you actually have Mr. Lee on page 854 of the Instagram record talking about them YFNs. And so that would establish that he knows who they are, and so you don't need the others. So that's true. All right. And if you think for some reason one of those others is going to be relevant, again, you're going to need to approach before you use it,
Yes, Your Honor.
because it shouldn't be needed for the reason that y'all just offered, considering page, whatever it was, 854. Okay. All right. And then what is this? What's on page 9?
I'll defer to Mr. Steele for the remainder.
All right.
It looks like there are notes, internal notes written over the document. I would not want that shown to the jury.
Yes.
We don't intend to introduce these notes. We're actually going to pull the actual thread. And I believe that was communicated in the email that we sent. But for brevity's sake, we wanted to show defense counsel where the language we're speaking of, but this is actually in Mr. Lee's Instagram return. So we'll find the actual, we'll have the
Okay.
actual pages of.
But what we need to be looking at is just the thread.
Yes, Your Honor.
Okay. And is there objection to the thread?
No.
Okay. All right.
If a proper foundation can be laid, which I believe it will, but no otherwise.
All right. And then I just got another email forwarded about Wooney Lee exhibits. These are pictures, maybe posts from somewhere. Is there issue about these? Do we need to litigate these?
1226.
Do y'all know
Woman
what
this
I'm
way.
talking about? States 36, 37 through, I don't know.
This is just the PowerPoint of the exhibits we plan to introduce during Mr. Lee's testimony, Your Honor.
All right. Is there an issue? Is there an evidentiary objection to 36 through 46 NN and then 4Y?
And most of these, Your Honor, were in the Wooney Lee folder that we went over a few weeks
Yeah,
ago.
I mean, if we've already litigated it, great. I'm just asking so we don't.
We did it a few weeks ago, but as far as 36 NN, 37 NN, and 47 NN, those are the issues that I brought up on behalf of Mr. Stillwell. Those involve Mr. Stillwell, and I brought them up yesterday morning.
Okay.
But as far as anyone else is concerned, these are not things that have been litigated, except the ones that I brought up yesterday.
Okay. So
The state
does
again.
anybody else have any objection to any of these items?
Your Honor, I was proceeding on the state's email, which was sent two days ago. This is what we need to review for Wooney Lee. So I've not had a chance to go through all of these.
Y'all are just too much, honestly, all of you, or most of you, not all of you, but a lot of you.
Your Honor, to be clear, so when we made the witness boxes from 1 through 30, 31 through 60, and 61 through 100, for the, there may be a photo here that, you forgot to put into this witnesses folder, but all from discovery. So when we're creating these, like the exhibit PowerPoint, some of it includes exhibits that are already admitted in the trial itself. It's literally the PowerPoint in order of how the state's going to ask direct questions of this witness. So there shouldn't be any surprises with what's in this PowerPoint in terms of, I don't know what day or week it was that we went through, but I know that there was a moment where we got through all of them, where the court would say, does anyone have any objections with this witness? Does anyone have any objections with Mr. Sprinkle, with Agent Burney? And we went through number by number. And of course, if an objection is raised, this honorable court will hear it from any party. But, when we say we haven't litigated or have litigated, in the state's minds, when these issues are brought up, does anyone have an objection on the floor for this witness and the exhibits the state has are indicated that they may use with that witness. If there's no response,
All right, well, take the lunch break and
Ooh,
look
I might be
and
right on
see
the
if you have
button. 12:30.
objection, and come back at 1:15. Yes.
And I can speak to one, just so everyone knows. I know I have an objection now. I didn't realize it was in this PowerPoint, but it was something that was recently the state recently indicated that they plan to use, which is number 12. That's a
I don't know
screenshot.
what you mean by number 12.
Number 12 on the PowerPoint. It's
Slide.
46 slide 12,
Okay.
46
46
NN.
NN.
And that's just a screenshot. I believe that to be a screenshot of the beginning of a 15-minute video. And I
Now she
believe
was
that
going to lunch and
video
Max Shard had to jump up again. Shut up,
is
Max.
titled something like A Night with YSL and 4L. I've watched that video. I've reviewed the video. It's basically a group of young men at a music studio and in the parking lot outside the music studio, and they're kind of interviewing each other, and I guess it was released as a promotional type thing. But I don't know why that 15-minute video would be relevant or admissible.
I can email over the different timestamps that are the most relevant portions of this video. It's not the entirety of the 15 minutes, and I'll do that before I leave court.
So are you saying you are only planning to play
Certain portions of the video.
certain little distinct parts of it?
Yes, and I'll send that over right now.
Okay, do that right now. And then when we come back at 1:10,
Ooh, change it to 110 from 115. Y'all keep
Yeah,
up. Y'all ain't going to have no break.
take it up. No, I'm not. No. All right, so anything else we're gonna need to deal with? Oh, so the limiting instruction, if nobody has anything else to add, does
Here we
anybody
go.
have anything else to add?
Come on,
on
Judge.
That limiting
Let's
instruction
go.
that I'll read.
You're 2 minutes
before
past what I said
Mr.
you were going to be. And I knew you weren't
Ryan's
going to be, 15, 20
conviction is
minutes.
entered.
Y'all never are.
I don't know as to whether we made a number 1 or number 2 decision.
Yeah, I decided it on my own because
Oh,
nobody
okay,
got
well,
back to me. I picked number 1.
That probably
So,
would have been my pick, but
all right.
I
good.
want to reiterate, though, that I agree with Mr. Steele's position that ultimately neither one of them eliminate the confusion from, boy, we can use some of this against some of the people, but we can't use some of this against some of the people. So I want to reiterate that
Okay.
and just reinforce that as well.
All right. So I have, at this point, I mean, I can send it back out, but let me just do that real fast. And I haven't changed anything with regard to, let's at this point just focus on the Mr. Ryan one. Let me get that over to Ms. Persfield so she can get it over to y'all. But I've taken out the reference to overt acts numbers or overt acts at all. Because when I started trying to craft something that would explain, hey, this is to overt acts, but that's not all you have to, find if you're going to find, when you're making your determination on count 1, I realized that it is not really just to overt acts anyway, that it could be taken into consideration in their determination of whether they think anybody was conspiring to engage in a pattern of racketeering activity. And that just goes down a whole,
Rabbit hole.
I don't know, wormhole, black hole, I don't know.
Rabbit hole.
Of having to stop and give the final jury instructions now, which I'm not going to do. So.
Yeah, I mean, it's kind of
So
crazy
I'm
there.
just saying, count 1.
Count 1. Mm-hmm. Yeah, okay.
Yes,
Your
sir.
Honor, on behalf of Mr. Stillwell,
God, shut up,
we
people, and go to
appreciate the court's
lunch.
efforts. And this is a difficult
Y'all are blowing your
situation,
lunch
and
break
we are just,
over stupidity. She
for
just
the
told you to
record,
come back at
joining
1:10 and y'all
with
still
the
going.
thoughts of Mr. Steele and with Mr. Harvey, that a jury instruction is not
Not
going to be,
enough?
is not
Okay.
enough. But I just wanted to place that on the record.
I mean, I assume everybody's joining in
Okay.
that objection, and that's fine. I've looked at a lot of different federal circuit case law involving RICO cases. And it appears that even when a conviction of a co-conspirator comes in, as long as a limiting instruction is given, there's not a confrontation clause problem.
And I just feel the need to bring this up at some point sooner rather than later. There are convictions of
Shut up,
Mr.
Max.
Jimmy Winfrey, my client, Mr. Stillwell, and I believe Mr. Nichols that have come into evidence.
Right.
We brought up these issues previously with the prior judge, and we were not given. We asked for them not to come in. We asked for limiting instruction, and we were not granted those things. So I don't know how we're going to cure that for those.
So I mean, I thought that we had discussed the Winfrey one, and I said I would just, at the end, when I remind them of all of the things that are only for certain purposes, do that. I didn't know that anything of Mr. Stillwell's had already come in without a limiter.
They have, and I believe Mr. Nichols.
Okay. All right. Well, then I will add those two to the limiter I'll get at the end. And again, they're not supposed to be deliberating until the end anyway.
Okay, so when you're saying at the end, you're talking about
The-
jury instructions.
My jury instructions, yes. All right. See y'all in a fairly short amount of time.
Okay, they're on lunch now, YSL, day 150. They're due back at 1:10. Jury is due back at 1:30. I will see y'all back here about that time. This is the Outcast Podcast here on YouTube live. Y'all enjoy your lunch. We'll be back here at 1:10. Right here on the Outcast Podcast. You are looking at the podcast here for the Outcast podcast. We are on a temporary hold pending the jury coming back at 1:30. Court's due back at 1:10. They have some more stuff they need to litigate. I'm going to bring up day 138, which is the day that what's going on there. So let's get into day 138 because I want to show you where she got in trouble for trying to bring stuff in that she was not supposed to bring in, misrepresenting to the court what she was doing. So I'm going to stop it right here, share this one here, jump over to here. And this is a replay of day 138. So let me put up a brief, let me put up a new banner here real quick. All right, let's see here. All right, so let's replay day 138 where love gets in trouble. Right here on the Outcast podcast, we are still on lunch.
And it also would be at the top of the vehicle where the particles are likely to shoot up when the gun is expelled, correct?
That's correct.
Okay.
Objection, Your Honor. Foundation relevance, 403.
Sustained as to foundation.
Well, as the drafter of the search warrant, you felt the place to look for gunshot residue was the headliner of the vehicle.
Yeah, I don't remember that.
Asked and answered. And with respect to
overruled
foundation
Because he didn't answer the last one because there was an
No.
objection.
and
You can
foundation.
answer that.
You thought the headliner was a good place to look.
Yeah, I don't know if I just in the search warrant I said only take out the headliner. It was probably broad enough to allow the law enforcement agents to be executing the search warrant broad latitude in the surfaces that they analyzed.
And you were interested in having this search for gunshot residue.
Good afternoon, DDA Sprinkle. How are you?
Very well. How are you?
I believe we
All right,
met
I'm gonna
once
speed this up
before,
just a
but
little
my name
bit
is Doug
because
Weinstein. I
I'm a little
represent
bit behind
Diamante
where I want to
Kendrick.
be.
Okay.
But we're
And
replaying day
you
138 right here where love messes up
asked as well about efforts that you
and where a
made
mistrial should
to
have
corroborate
been
information
called
that
but
you
was
were
not.
given
But here we go.
during specific interviews. Do you recall?
I do.
I'm going to show you what has been marked as State's Exhibit 528 Yankee. And ask if you recognize 528 Yankee.
I do.
How?
This is a picture that I obtained from Justin Cobb's Instagram page that I screenshotted.
Okay. Why did you, let me ask you first, is 528 Yankee a fair and accurate copy of the screenshot that you got from Justin Cobb's Instagram page?
Well, yes, though it's cut off a little bit on the right, where the timestamp is, the last number of the timestamp, it just says 201.
Okay.
But I mean, I recognize that it's otherwise fair and accurate. It's just cropped a little bit on the right-hand side.
Your Honor, the state tender states 528 Yankee as evidence.
I would actually object to it if it's not in the exact.
If it's what?
I'd actually object to it if it is not as he remembers it to be, if it's been altered or if it's not the same that he's viewed previously.
Okay, well, it is admitted, subject to the understanding that the date isn't to be relied on because we can't see what the date is.
And I'd also object to any hearsay that may be contained within that document.
I don't know if there, I don't know what the exhibit is. So is there? Is that an issue I need to take up?
I don't believe so, Judge. I mean, I can show the court in.
Okay.
Right on the side, take a look at it.
Okay, so here's where Love's going to go up to the bench and she's going to say, "I'm not using any of this for the truth of the matter asserted. I don't need the text and yada yada yada." And then she's going to get DA Sprinkle to go to that exact phone number and try to say who it was and all that after she told the court she wasn't going to do that. And she gets in trouble with the judge for doing this. Again, this is Outcast Podcast, coming to you live on YouTube. Court is at lunch right now. They'll be back at 1:10. The jury will be back at 1:30, which I anticipate later than 1:30, the jury getting back, because I don't think they're going to get done with what they need to get done within that amount of time. I really don't see that happening. I could be wrong, but I wasn't a few minutes ago when I told you I was going to be past 1:30, and it was somewhat past 1:30. Continuing coverage of the YSL trial, day 150.
And Mr. Sprinkle, I'm going to show you the digital version of 528 Yankee and ask you, are you able to see the date on the digital version?
I am.
Your Honor, state. Since there's 528.
Okay. So are you going to, it'll ultimately be, are you just going to make a better copy and substitute?
Yeah.
All right, that's fine. Then it's admitted in full.
Thank you.
Continuing coverage of the YSL trial, day 150. Court is on break at the moment. They are due back at 1:10. Jury is due back at 1:30. This is a replay of day 138 here on the Outcast Podcast.
As we're pulling up 528 Yankee, would you tell the jury what significance you found in 528 Yankee towards your investigation?
Well, there was a phone number posted it was a public post, and there was a phone number that was, there's a comment section to the right of the photograph, and there was a phone number posted by the account holder that appeared to be their own.
Okay. And was the account holder Justin Cobb?
Yes.
What was the significance?
I'm going to object to that as hearsay and ask it to be stricken.
Which part?
Part about who the number belongs to.
Sustained.
Okay. What did you do to determine whose account this was?
Well, I looked at the photos that were posted in the account, I believe. Now for the traditionally, that's what I would do with an Instagram page. It's just posted in public view.
Okay. And what was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment and.
Posted by the owner or user of the account?
That will call speculation, I'll object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name name the number is next to.
I
What
would
handle
renew
the
my
number
objection
is
and also
next.
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay, when
Your Honor,
when we were up here at the bench,
so, Your Honor, I'll ask additional questions that I think will,
sustained.
okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Now, see, Love is trying to be slick. Oh, it's already in evidence. It's in evidence, but it's not in evidence for the reason you gave at the bench. And then you get up there and you put this in front of the jury. And to me, all of DDA Sprinkle's evidence at that point should have been out. His testimony should have been out, stricken from the record. He should have been gone. Anything associated with him should be gone. Any evidence he collected should be gone, off the record, out. And that would teach the state to behave, because they pull this constantly. This is not the first time. He was rebuked for the same thing weeks ago in front of the jury.
Your Honor,
And here she goes doing it again.
Mr. Smirker, you can go ahead and step outside for us. Thank you.
Your Honor, so well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
may I respond?
You may.
Judge,
Can somebody put the document up? I don't see.
yes. Would you put it up? First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with, where's the phone number? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor.
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked, though. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around And after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because this is a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number one of the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked that.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant.
We are just a couple minutes away from court coming back in. This is day 138 replay. DDA Love getting in trouble for.
But you know, Judge, we don't get there.
Come in.
I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate.
Once they come back, I'm gonna let this pipe in. Get us
I asked for everything that was on the right side. All of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean,
very specific.
Listen, none of us are obtuse. Here. It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is.
They're waiting on court to come back in. I'm watching this other screen.
That somebody
as they come back, we'll rejoin
number
them.
of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way
Because you
in
don't,
which it is
because you're trying to
being
get stuff
presented.
in that you know that it can't come
I'm going
in.
to take a recess for a few minutes.
So let's get in front of the
I'll
jury. They
have a
won't,
ruling
they'll
when I get
remember it.
back.
No, even though if the judge tells them not to, they'll remember it and we'll be fine. All right, this is Outcast Podcast coming to you live right here on YouTube. We are waiting for the jury to return, or the court to return. They're on break. They were supposed to return at 1:10. It is 1:12. They are not back yet. So we're just waiting on court to come back in. Let me refresh here. Looks like I'm having some audio issues. Just my streaming software letting me know connection was lost somewhere. All right, there we go. So we're just waiting on court to come back in, folks. YSL Day 150, waiting on them to return. They were due back at 1:10. They're not back yet, so the judge must be eating because Max Sharp wouldn't shut up. Kept wanting to bring stuff up. And the defendants have to get their lunch by law. They cannot be forced to eat fast because of the court. They must be given an appropriate amount of time for lunch. So, if I was the prosecution, I would be like huddled up with the defense right now and be like, you know what? Let's try to work this out. Let's get out of the, and help me get out of the way of the judge here. Help me get some cover, and I'll help you out. But no, they can't do that. Outcast Podcast Live YouTube. Day 150 YSL. I'm going to be doing a few podcasts, pre-recorded podcasts over the next few days. Going into the life and times of some recent famous cases. And by recent, I mean the last 20, 30 years that could really use some, that nobody, I think, is really going back over and detailed everything on. And that's what we're going to do here. We're going to go in and we're going to bring up some of these older cases and we're going to show some highlights and go from there. This is the Outcast Podcast coming to you live. Waiting on court to return. They went to lunch. They were due back at 1:10. It's 1:15. They're not back yet. I think it's maybe the defendants are still eating. Like I said, the defendants by law have to be, they have to be given a certain amount of time to eat their lunch. They can't be rushed. They can't be forced. It's like if they were in prison or jail, they would, they have a certain amount of time they're allowed to eat. And so, and I'm pretty sure the lawyers for the defense are probably huddled up pretty tight right now, trying to decide how to approach this. And if it was me, I would be 100% filing a motion for a mistrial, and I would be listing everything that Love's done from when she was reprimanded from the court, day 138, today, yesterday. There's so much they could just put into a motion, and just to codify it and make it easier for the court to overturn. And it's going to get overturned. There's no way this does not get overturned, folks. I'm sorry. There's no way. This thing goes up on appeal like it is right now. It's reversed. And it's being done all over again. And then Judge Whitaker can probably do it the right way at that point by letting certain things in and not letting certain things in. Still waiting. The waiting game. By the time I get it, we'll get something to eat. They'll come back. And I wanted to give y'all something to watch, keep you on during the break there, keep from getting too bored. And I think that kind of backfired on me there because I could have went to lunch. But hopefully it won't be much longer and they'll be back and we can get things rolling again. All right, I see some heads in the courtroom, so we must be getting closer there. All right, I got the volume up in the courtroom. Turn the music down a little bit here. And we're just waiting on them. That's the Outcast Podcast. YouTube, Day 150 YSL. Started the day out with a mistrial motion. Before we went to lunch, there were some more questions on this Wuhan witness and some questions on some of the evidence coming for them.
I love it. You guys are so great.